My lord, I beg to mention item number 52, my lord, in the hearing list, my lord. Since long back it is in the list, my lord, it may be taken up to, my lord, subject
No,
to, my lord, as a last matter also, my lord. Because since long back it is, there is no interim order also, my lord. And
as,
civil nature case, my lord. My sister's daughter mutated my father's land, my lord.
as per the, we'll try to take it up.
Yes, my lord.
In bail application, my lord, I filed it yesterday. May I play one can take it up tomorrow, my lord, for motion.
What are the men?
My is regarding, my lord, both are behind the bars from, my lord.
No, what is the offense?
My is regarding my main allegation, my lord, is regarding
Offense is more than 7 years.
misappropriation of money, my lord, where the punishment, my lord, 420 and 379 is still, my lord, 60 days, 7 years maximum. Now, my lord, they were at 413. As a result, my lord, mentioning it there.
I beg to mention item number 61 of supplementary list. Your lordship yesterday fixed it at 2 p.m. My lord. Orders also reflect, but my lord, in the cause list, it's not reflect, my lord. The order sheet also, my lord, reflect.
Okay, we'll take it up at 2.
Nepalese, your lordship, my lord. I beg to for listing one anticipated bail application on tomorrow, my lord.
More than 7 years.
Out of same affair fixed on tomorrow, my lord. On bail application.
Offense is more than 7 years. Punishment is more than 7 years or
Yes.
not? Okay. Okay.
Okay.
May I please your lordship? I beg to mention item number 30. Lordship, learned counsel of the petitioner will unable to present due to his personal disease. So kindly adjourn the matter for next.
My lord, case diary received.
On request of, yeah. What is your name?
A.M. Rahman.
Mr. A.M. Rahman, learned counsel for the petitioner, who prays
Yes.
for an adjournment. This matter is listed again on Monday. Monday is 16th.
My lord, 30 CD not received, my lord. Sorry, my lord. 30 case diary not received.
Case diary not received. Listed on, let it be listed on 20.
Sir, lordship, next Monday. If
Case
the
diary
case
is not there.
received, then fixed for the next Monday, lordship. Item 30. lordship.
Whether by Monday you will be able to bring the case diary, Mr.
Monday, my lord, not possible. On 18th, my lord.
18th. The issue reminder for the case diary.
Must object.
Wait, please, lordship. Lordship, item number 9 may can be taken at 2.
2 we have already fixed matter.
Have that
Item number 9 after bail hearing.
oblige.
Your Lordship, I want to beg item number 56 of supply list. I want to withdraw this case with liberty to file the case in before the trial court. Charges are already filed.
Okay. Heard Miss M. Day, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This case is dismissed on withdrawal.
Oblige.
May I please, your lordship? Lordship, I beg to mention item number 41, seeking adjournment. My senior is out of station.
What is your name?
Yeah, Hussain.
Heard Mr. A. R. Hussain, learned counsel for the petitioner, who prays for an adjournment on the ground that his senior, Mr. R.P. Hazarika, is out of station. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Madam, item 23 and 36. These 2 items in at maybe at 2 p.m. I have some personal problem.
No, 2 we have fixed matters. We'll call it serially.
Please, your lordship. Lordship, I beg to
mention a matter, fresh matter for listing for tomorrow, AB, filed on 6/9.
More than 7 years
Yes, Your
punishment. No. When have you filed?
It's filed on 6/9,
Okay.
tomorrow, Your Lord. Please, Your Honor.
Your Lordship, I beg to mention item number 49.
Yes.
So matter will be taken up after 2 weeks, Lordship. A date may be fixed that, can it be on 1st of October?
No date. No date. What is your name?
I will say.
Heard Miss I. Hussain, learned counsel for the petitioner who prays for an adjournment. Why are you praying for adjournment?
Senior is out of station.
On the ground of personal difficulty of the conducting counsel, considering the grounds mentioned by the petition counsel, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
May I please, Your Lordship? Your Lordship, in this matter, Your Lordship, the charge sheet has already been filed.
Heard Mr. What is your name?
D.S. Deca appearing on behalf of Mr. T. Deori, Your Lordship.
Heard Mr. D.S. Deka appearing on behalf of Mr. T. Deori, then counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. Stop. Prayer is allowed. This case is dismissed on withdrawal.
Much obliged, Your Lordship.
Last item is 7.
Item number 1.
May I please, Your Lordship? 483 application, Lordship. I am behind the bar for 52 days, Lordship, as of today. And in fact, Lordship, the FIR, Lordship, is at page 8. The case is, Lordship, perhaps it is a case of theft, but the section 3096, that is robbery, has been, Lordship, registered. And the whole allegation, Lordship, against 2 persons, not against the present.
Case diary would be required.
Yes, ma'am.
Heard Mr. A.M. Khan, learned counsel for the petitioner. Also heard Mr. P. Bothakur, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence call for the case diary fixing
On 23/9, ma'am.
23/9
9.
for case diary. Number. Case diary goes to parking, same format list for you, more from case diary.
Matter law statement. 439 earlier night. When your lordship will find page 11 is there here. What happened? This person 73 years old, Myra. And because of the some land dispute with the informant, you will kindly see page 11, Myra, that will be clear. Purely civil matter, Myra, given criminal color.
What is 108?
10306 earlier.
Okay.
Abatement to suicide.
Yes, Mr. Bothakur.
You will kindly see it is Myra further detail matter, Myra, he is offense.
When were you arrested?
Arrested on 9 Myra, 9 arrested, 10 forward. 10/8. 1 month.
Where is the rejection order? Why?
Yes, this order is here, Myra, page. Page 23,
Why it has been rejected?
page 23. Your lordship will find text of the case 20, page 23, second, third line. Mutation, my lord, his name initially, it was in his name, it was mutated. Subsequently, he found that his name is not there. Mutation has come in favor of the present petitioner and others. Therefore, he committed suicide. And there is an order, my lord, title suit is there, already injunction order is there. That mutation was done in terms of the order of the law approval.
case diary would be necessary.
I don't think, madam, you follow kindly see, madam, in the face of
The,
FIR,
at page 25,
23.
no, at page 25, the
23,
tri-
madam, that
trial
is,
court,
your lordship, what happened, Ajhar was got by the informant namely so-and-so, to the effect that the accused person, Pankaj Sikya, Kundal Sikya, along with other brothers, Pallab Sikya, sold their plot of land situated at the person to their father, this is so-and-so.
yes, Mr. Bhattakur.
CD will be required, otherwise, from the contents of the rejection order, it is specifically mentioned that,
No, that's not a matter, your
Because,
lordship, on the face of the matter, there is a
and-
title, so.
and from the contents of the FIR itself.
We are
so-
fixing a short date.
so that-
Madam, I am just saying that, madam, you will kindly see, just page 46, madam, page 46.
No, but the Sessions Court, after perusal of the case diary, has Come
That
to
is
the
there,
finding.
madam, normally, your lordship, but this person after arrest, he was again taken medical open surgery, medical college, my lord, he was there for.
we are fixing a short date. Short,
2-3 days, my lord.
when can you bring?
On-
Possible,
On 18/9,
15 days, you know. You Friday, Friday.
yes,
Man will die, madam, it's very serious condition, madam.
and 17/9.
Heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Ms. R. Dekar, learned counsel for the
No,
petitioner. Also heard Mr. P. Bhattakur, learned additional
Madam,
public prosecutor.
16, I agree here. Very serious condition, madam.
Perusal of the case diary would be necessary for consideration of the instant bail application. Hence call for the same. Fixing 16/9/2024 for case diary,
16.
16/9.
May it please your lordship.
3 and 4, my lord,
Four
wrong.
kindly be taken up first,
My
lordship.
lord, 3 and 4 wrongly listed for motion, my lord, earlier CD was called for, my lord.
Lordship, 3 days, today, lordship, can you peruse the last order, lordship, that is first listed on 28/8, thereafter on 6/9, then lordship 10/9, lordship. On last day, lordship, 6/9, lordship, it was specifically directed to place the case diary, lordship. May I take you, lordship, the
Case diary is there or not?
My
case
lord, I will
diary,
have to
on last
inquire
day,
from
case
our-
diary was there, lordship.
Huh?
Can you take
I will
it
have
up
to
to?
inquire from our office, my lord, because matter is listed for motion for which, my lord, probably, my lord, case diary is not attached.
Okay, let him find out. We'll take it up as first bail hearing item.
Otherwise, my lord, there are lots of
At
bail hearing
loss.
matters, my lord, there are lots of bail hearing matters today, my lord, so after.
At 2, lordship, because of 74 days in jail, lordship.
Your lordship has already fixed other matters at today after, my lord, after taking up that matter, my lord.
Okay.
Yes, my lord.
Alio.
May I please your lordship? My lord, the affair at case, my lord, 9, my lord. Case 9, my lord, this is the affair, my lord, where we are not named even. But actually, we are the affected party, my lord. First, we have lost the affair, my lord, and we are injured, my lord, bodily injured, my lord, and then medically examined also. Therefore, when the incident took place on 27th, my lord, we went with the affair to the dispute PS, my lord. Dispute PS, my lord, sent us to the hospital, my lord, for medical examination, my lord. And thereafter, my lord, we lost the affair, but still, to our knowledge, my lord, that affair is yet to be, my lord, registered. Now, the affair in which we are seeking bail, my lord, we are not named, even though, my lord, fairly submit that, my lord, there was an altercation, my lord, between a shopkeeper and the petitioners, my lord. When we made online payment, my lord, he said payment has not been received, my lord. Then we displayed the, my lord, online payment history, my lord, and regarding this altercation took place, my lord. But the affair, my lord, lost by, my lord, a third party, my lord, he is never involved here, my lord. And that is written in English, my lord, kindly see, my lord. The affair
Now,
pays-
what is the injury caused? Injury, what
Injury, my lord.
injury was?
Nothing, my lord. No injury report, my lord. Nothing, my lord. Kindly say, we are affected, we are injured. Page 17, my lord. But our affair, my lord, was lost earlier, but it is not registered yet, my lord. Page 17, my lord, this is medical examination report, my lord.
Though you are not named, but
No.
you were involved in the.
Yes, my lord.
Involved only that much, my
And-
lord. Altercation took place because I made, my lord, online payment of ₹100.
But we don't know what injury is
Yes, ma'am.
caused to Amlan Devnath. Who was injured?
Injured, my lord, the petitioners, my lord, petitioner number 2, my lord.
No,
They
no,
are their own brothers, my lord.
that, but in, as per this FIR, 28/8,
Yes, my lord.
who was injured?
A group of people, my
The
lord, I
brother,
think,
elder brother of the
and
informant,
earlier,
Yes,
my
my
lord,
lord.
Amlan was injured.
yes.
What was the injury?
Injury is nothing, my lord. They cannot show, my lord.
No, I will put it.
No injury.
Yes,
We are injured, my lord.
And
We are
1182
injured.
and 1182 is my corresponding provision is 326 criminal intimidation is also there.
They are two
What are
brothers.
the
my lord.
offenses?
Yes.
Offenses, my lord, 118, my lord, 2.
Earlier, my
don't-
lord,
don't.
1152, that is, my lord,
Name the offense. What are the offenses?
my lord, voluntarily causing hurt. 326 earlier corresponding provision 326 is also there. Criminal intimidation is also there. And 34 is common intention. 353
Case diary may be required.
required.
Then, my lord, till then we may be protected, my lord.
A group of people,
No,
why they
are
attack,
two brothers only.
only CD will reveal.
And
the
affair,
actual-
my lord, affair, my lord, that is written in English. That shopkeeper, my lord, could not write, my lord, this affair in English, my lord. Third person, my lord, involved in this case, my lord.
From Dispur PS, I can produce the case diary on 18th May,
On when?
on 17 or 18th May.
So on till 17, wait,
There's some protection, in some case,
wait till that day.
some protection, my lord, may kindly be
Heard
given.
Mr.
AFNU, my lord.
AFNU Mullah, learned counsel for the petitioner. Also heard Mr. P. Borthakur, learned additional public prosecutor. Considering the nature of offense involved in this case, perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence call for the case diary. Fixing 17/9 for case diary. 17.
Protection, my lord.
Let the case diary come.
Oblige.
Made girls. Earlier 376, man.
Oh,
And
then case diary would be necessary.
Earlier 492.
okay,
Earlier 492, yes.
no, earlier, this section is now 64. Just you look kindly see, madam. Father filed an FIR and she herself also filed an FIR earlier, madam. You have kindly see.
Where is the FIR?
All are involved. Father, yes,
At page?
page 13. This is, madam, you will kindly see two FIR, madam. Actually, one filed by the victims earlier. Thereafter, madam, this one filed. So both your loss kindly take us, then your loss pass in order. Madam. Page 13. Total your loss is 7 persons. Number one, when a marriage took place with number one, this victim, every victim. Rest are father, brothers, uncles, etc. Informant begs to state that the above noted accused number one has committed so and so, my lord, without my knowledge by inducing to marry her, and as a result, she was last on so and so accused person kidnapped her while she was proceeding to school and kept in an unknown place. On 15/12/23 night, the accused person left her in front of the switch gate of her village in senseless condition. Immediately, I have intimated the matter before the Ramdia police. In charge called the accused number one into a police station and allowed them to go after about 3 hours and did not register the case, knowing that she is already married. The EC has made a conspiracy that my daughter was married with the accused number one to save him from the rape case. Allegation against the policeman. Thereafter, I came to know from the Nima that on last 13/12/23, the accused persons had consumed her psychotic substance and forcefully taken her at so-and-so Gandhi Hospital by a car, accused number 6 and 7 by bike. The accused number 5 being an employee of that hospital admitted Nima and conducted abortion of 5 months old to the, this is also false, madam. The accused number 4 remained in the hospital with her till 15/12/23. The illegal activities were conducted by doing senseless of Nirma, and she came to know about the abortion about after her sentence. On 15/12 at night, took her from the hospital and left her in switch gate. The accused person threatened to kill her if she disclosed the fact before the police, and as such, Nirma did not disclose the fact before the police. On 16/12/23, accused number 2. That's the important. I kept Nirma alone and sent the accused number 1 to the unknown place and made a drama of marriage just to save from the rape case. Thereafter, last so-and-so night at 1 a.m., accused number 2 and 3 left Nirma in my court here. I have intimated the matter before the Amdia police outpost, but in charge did not take any action. Now, kindly see what she filed, madam, prior to this. Page 20. Yeah. Page 21. 34/24 she filed. The present one filed, my lord, father filed on 25/7. After 3 months now. Now she is saying your loss kind of page 21. With due respect,
Page 21 is a type copy.
page 21.
No, whether it was registered.
GD entry was made. Your loss by GD entry 23, page 23.
Yes.
Here she said, with respect to said that on 29/4/24, at about 3:30, I went to my husband's home from my mother's home, and as such, my father-in-law and mother-in-law, the accused number 2 and 4 scolded and assaulted me, and the accused number 3 uttered filthy language. And at night at about 12:30, accused number 3 left me and my husband in my mother's home by a car, and our marriage was solemnized about 7 months. But an amount of rupees 10 lakh has been demanded as dowry from my house and myself since the marriage, and the threatened to drive me out if not given. It not allowed me to live in my husband's home. Last night at 11:30 p.m. scolded my mother and father. GD entry. Now kindly see page 20. Marriage of her father himself is a witness to the marriage, my lord. And now he said the Dhamma, my page 20, you lost. 20. Yes, okay, page 20. Page 20.
What is this?
Page 20. Marriage. Page 20.
What is this?
His name is my also left side, my lord.
No, no, what is this? This
Oh,
annex.
it is marriage, my lord. Kabin Nama.
No, it appears to be page of a register.
Yes. And your lordship, this informant name is there, man. He himself is a witness, my lord, about this marriage. Arana, my lord, your lordship, second left side, on the left side. Yes.
No, what is this? Annexure to.
Its correction is the father says that married drama had that.
No, no. What is this? This annexure to. What it is called?
Or it is said marriage was valid, marriage was done legally. She is the wife of accused number 1.
No, I have understood. What this page is known as. What this annexure, the document which you have annexed as
Right,
annexure
right.
to. What it is called?
No, it is only, it is called Kabin Nama.
It is not Kabin Nama, therefore I am asking. Is it Kabin Nama?
It is my government marriage registration certificate, otherwise say.
It is not is it a certificate?
It is a certificate given in proof of the marriage. Man. This is also there, madam. You have given certificate.
That may be a certificate,
Yes.
but
So ultimately that was registered, my lord.
it is a form.
It is a schedule, my lord. It is a form annexed to the Marriage Act. And that was filled up. This is page 20. His own signature is there. This girl's victim signature is also there. And accused number 1 is not before your lordship. Father, mother, brother's wife, brother's etc.
My lord, it is specifically mentioned in the FIR that these are all and make a drama. They are all making a drama, my lord, of marriage just to save from rape case.
Government's
It is specifically mentioned in the FIR.
What is at page 20?
Page 20, my lord.
Government of Assam Sarkar, Assam schedule number 7.
No, genuineness
is
of all the, on the CD will reveal the actual fact. Otherwise, from the contents of the FIR, it reveals that initially false promise of marriage. Thereafter, my lord, she became pregnant. Thereafter, allegation of
No,
abortion.
but she has not in her own FIR, she had not alleged pregnancy.
But
The FIR which she filed 2 months ago.
Yes, of course.
In that, she has not alleged any pregnancy. And FIR lodged after 2 months after that FIR, the relatives are alleging 5 months pregnancy.
Initial FIR was not registered, man.
But
GD entry is there.
a GD entry has been made
GD entry.
at page 19.
Yes.
Okay, let us call,
Regarding accused number 1 and 5,
who is
One not
accused,
before lordship.
who is a petitioner number 1? His father
One
is
is by the husband.
father,
Oh,
And-
sorry. my
and
father.
accused number 5, because he is an employee of that, my lord, hospital, my lord,
That
where
is-
abortion
if
took
there
place.
is
That
a
is the allegation.
abortion, then question, she is not saying mine. Accused number 1, my lord, Shahid Nazir, son of Jabbar Alim, he pays 13, your lordship. He is
Okay.
not before lordship.
heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Mr. M. Hussain, learned counsel for the petitioners. Also heard Mr. P. Borthakur, learned additional public prosecutor. This application under section 482 of the BNSS, 2023 has been filed by the petitioners, namely 1, 2, 3, 4, 5, 6, 7, 5 and 6, naam likhibo, who are apprehending their arrest in connection with RPOPS case number 272/2024 under section 318 within bracket 2/64/61 within bracket 3,
61-2, it would be 2.
61-2,
Two. Wrongly accepted.
61 within bracket 2/89 of the BNS, 2023. The gist of accusation in this case is that on 25/7/2024, one Haran Ali had lodged an FIR against the present petitioners and one Shahid Nazir, before the Superintendent of Police, Kamrup, inter alia, alleging that the accused number 1 named in the FIR, namely Shahid Nazir, had committed physical relationship with the daughter of the first informant by inducing her with a false promise of marriage. Stop. It is also alleged that on 13/12/2023, the accused persons named in the FIR had kidnapped the daughter of the first informant when she was going to her school. And on 15/12/2023, the daughter of the first informant was left in front of the sluice gate of the village in a senseless condition. It is also alleged in the FIR that the matter was reported to the police. However, the in charge of Ramdia Police Outpost called accused number 1 and 2 to the police station and allowed to go them without registering any case. It is also alleged that petitioner number 5 petitioner number 4 who is an employee of Mahatma Gandhi Hospital at Swankuchi, had admitted the victim when she was pregnant carrying pregnancy of 5-month-old in the said hospital and caused her abortion. Stop. It is also alleged in the FIR that on 16/12/2023, the petitioner number 1, who is named as accused number 2 in the FIR, took the victim girl to an unknown place and carried out a drama of marriage to save his son from the charges of rape. Stop. Learned senior counsel for the petitioner has submitted that the allegations leveled against the petitioners in the FIR are not true. He submits that before the said FIR dated 27/7/2024 filed by the informant Haran Ali, the victim girl herself lodged an FIR on 30/4/2024 before the in charge of Ramdia police station, where she has stated that Shahid Nazir is her husband, and she has made certain allegation of torture and demand of dowry by the other accused persons. Learned counsel for the petitioner has submitted that the victim girl has been married to the accused number 1, Muhammad Shahid Nazir, as per Islamic rituals, and her marriage was also registered. Where it was registered?
Huh?
Registered before the Office of Muslim Marriage and Divorce, Registrar, Borpeta, Sadar. Stop. Learned senior counsel for the petitioner has submitted that the accused number 1 is not before this court, and the petitioners who have filed this anticipatory bail application are only the relatives of accused number 1, and they are ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has submitted that perusal of the case diary would be necessary for consideration of the instant bail application. Hence, praise for calling the case diary. Stop. Let the case diary be called for.
On 26/9.
Fixing 26/9/2024 for the case diary. However, considering the submissions made by learned senior counsel as discussed herein above, as well as considering the documents annexed along with the bail application, from which it appears that the victim is the wife of the accused number 1, Shahid Nazir, the above named petitioners, namely 1, 2, 3, 4, 5, 6, 7, 5, 6, are directed to appear before the investigating officer of Ajo PS case number 272/2024 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with Hajo PS case number 272/2024, the above named petitioners shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this matter be listed again on 26, 20, 26, 9.
26.
26.
American lawsuit. 438 application, my lord, FIR is case 8, my lord. Informant is aged about 30 years lady, my lord. And petitioner is aged about 23 years, my lord.
Still, FIR case diary would be necessary, considering the allegations.
Allegation is my lord totally vague, my lord. Kindly see para 4, my lord, of my petition, my lord. Yes, please.
Yes, Mr. Bhattakur.
My lord, it
but-
cannot be said that my lord, allegations are vague, only CD will prove, my lord, otherwise allegations are there. The last portion also, my lord, your lordship may kindly see.
Can you see para 4 of
Any sort,
No, but FIR makes,
FIR is page 8, my allegation, my lord. In the night, my lord, at about 10 PM, my lord, petitioner entered the room and grabbed her mouth and raped her, my lord, forcefully. That is the allegation.
yes, that is enough to call for the case diary. Heard Mr. A.M. Ahmed, learned counsel for the petitioner. Also heard Mr. P. Bhattakur call for the case diary
Along with the medical report. My lord.
along with the medical report. Fixing
on 24/9.
24/9
You know,
for
it
case.
states, my lord, after 1 month, the affair is lost. My lord.
Okay, we'll consider on that day.
It is on 24/9.
Please, Lord, sir. My lord, here, my lord. Petitioner number 2 is the wife of petitioner number 1, my lord. There was some dispute, my lord, between small dispute, but it is sorted out. Compromise between the husband and wife, my lord. Can you see, my lord, annexure A, page 10.
That is the FIR.
Annexure A, my lord, page 10. Table of the compromise, my lord, okay, sorted out and living peacefully together.
Who is the petitioner?
Petitioner,
who is the first in-
husband and wife, my lord, both.
No, but who is the first informant? Wife? Whether wife has filed any affidavit? Sophia Begum.
Matter has been called the compromise by now, living together. They have got, don't have college going.
Do you have any citation? Lakshmi Narayan's case citation is there with you.
This is my lord, I have to, this is my lord. Same debating case, my lord. Identical case. One is our High Court and Supreme Court,
Which one is of Supreme Court?
my lord.
What is the citation?
498 A.
Yes, Mr.
Yes, otherwise, the joint petition affidavit is filed by the
One petition.
wife, no, 498.
Third, Mr. B. Najari, learned senior counsel, assisted by Mr. P. Majumdar, learned counsel for the petitioners. Also heard Mr. P. Borthakur, learned additional public prosecutor. This application under section 528 of the BNSS, 2023 has been jointly filed by the petitioners, namely Shri Ahmadul Hajorika and Muhammad Sufia Begum, praying for quashing of the charge sheet and consequent. What is the case number?
PRC case number 1850.
And the PRC case number which arose out of the said charge sheet. PRC case number
1850.
50, where it is mentioned.
Prayer person, prayer person.
15,
Page 2.
1850/2021, pending in the Court of Learned Chief Judicial Magistrate, Kamrup Metro. The facts relevant for consideration of the instant criminal petition, in brief, are as follows. That on 8/2/2018, the petitioner number 2, Muhammad Sufia Begum, had lodged an FIR before the officer in charge of Dispur police station, inter alia, alleging that her husband Amdadul Hajorika, who is the petitioner number 1 in this case, used to torture her after consuming bhang, and on 7/2/2018, he drove the petitioner number 2 out of his house and also tried to assault her with a dao. Learned counsel for the petitioners has submitted that both the petitioners are husband and wife in relationship, and they have 2 grown-up college-going children, namely Sajid Hazorika and Muskan Mehak Hazorika, who stay with them. It is also submitted by the learned senior counsel for the petitioners that the petitioners have amicably settled their dispute amongst themselves and are now residing peacefully in their rented house with their children. However, learned senior counsel for the petitioner has also submitted that considering the settlement which has been reached between the parties, there is a bleak chance of conviction in the case, and therefore proceeding with the PRC case number 1850/2021 would only be an abuse of the process of court. Learned counsel for the petitioner has also cited following rulings in support of his submissions. Number 1, Jasmeer Singh and another versus State of Haryana and another, reported in 2022, 9 SCC. 73, stop. Number 2. Badana Begum versus State of Assam, reported in 2013, 1 GLT 692. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record. This application has been jointly filed by both the petitioners who are husband and wife in relationship, which itself shows that they have amicably settled their dispute amongst themselves. Though the section 498A of Indian Penal Code, under which the charge sheet has been laid, is a non-compoundable offense. However, there are catena of rulings of the apex court as well as of this court that in dispute between the family members, mainly more so in matrimonial dispute, where the parties have reached amicable settlement amongst themselves and where there is a bleak chance of conviction in the ensuing trial, in the pending trial, it would be an futile exercise to proceed with the pending trial, and proceeding with such a trial may amount to abuse of the process of court. Stop. You have filed the charge sheet, copy of charge sheet. Have you annexed?
Yes,
Where? At page?
page 15 onwards. 15 is the type copy, 16 and 17.
It also appears from the charge sheet that the petitioner number 2 is listed in the charge sheet as the main witness for the prosecution side. And when she has herself settled the dispute, there is unlikelihood that the pending criminal case against petitioner number 1 would result in conviction. Stop. Under such circumstances, this court is of considered opinion that this is a fit case where the charge sheet and the pending case against petitioner number 1 may be quashed by invoking powers of this court under section 482. Under section 528 of the BNSS. Stop. Which this court hereby stop. Accordingly, the charge sheet filed in ERC case number 1850/2021 against the petitioner number 1 is hereby quashed, and this criminal petition is accordingly disposed of. Criminal petition के लिए क्या है करना है?
May it please the lordship. No, this is an application number 482 BNSS. FIR, your lordship will find page 12. The type copy of the FIR, your lordship will find page 16.
What are the offenses?
You know, the offenses are with regard 143,
No,
10, 61.
name the offenses.
Yes, my lord, the kidnapping, dacoity, criminal conspiracy.
Kidnapping or
the-
abducting for ransom money.
The petitioner, before your lordship, was the driver. Look what happened in this matter, my lord. One Sri Rahmat Ali contacted the informant and Sumed Ali for doing some mystery work in Arunachal. And both of them came to Lakhimpur through another Tikadar, that is Abdul Sadek. Now this Abdul Sadek was to take them to Arunachal for the construction work. Now, as per the FIR, page 16, two vehicles are involved. One vehicle is Bolero AS07X5625. This was the vehicle which the petitioner was driving. The petitioner was hired to drive this vehicle. The petitioner is a part-time driver, my lord. He earns his livelihood by driving car of the people of the locality upon payment of some money, my lord. So he was hired to drive this vehicle and he drove this vehicle. Thereafter, there is another vehicle.
Who was kidnapped? Who was
This-
abducted?
The informant, that is my lord, Hobijul Ali and Sumed Ali.
They were abducted.
And allegation is that the accused number 1 and 2, they, my lord, threatened them and snatched money from them. There is no allegation against the petitioner.
What is the name of the petitioner?
Petitioner's name is, my lord, Masood Hassan.
Masood.
As because he was driver, so he was caught. My lord, what happened, my lord, when we, initially all the complainants, the accused, they took a dinner and thereafter, my lord, moving to the Arunachal Pradesh, then village defense personnel, my lord, they
Case diary will
Stop.
be necessary
yes.
because you were there.
No.
You did not participate because you were driving.
No, there was no participation on my part. My lord, what happened in this case? First vehicle, the petitioner was driving. They, the accused number 1 and 2, they went for a dinner. They went to take dinner. The complainants were there in the car. And after completion of the dinner, they headed towards Arunachal Pradesh. My lord, at one place, the village defense personnel, they stopped the car and they checked the identity of all the passengers. In that thing, my lord, the accused number 1 and 2, they had a quarrel with village defense personnel, and the village defense personnel stopped the vehicle there, get hold of accused number 1 and 2, and I was directed to move from there. I left the vehicle and I was directed to leave that place. So I came by, I left the vehicle there and I came back to my place, my lord. That is para 4 and 5, my case. So I was no way involved, my lord, in the entire thing, my lord. I was hired to drive the vehicle. I drove the vehicle. Village defense personnel, my lord, stopped the vehicle, and I was directed to go.
Case diary. Yes.
Yes, my lord, otherwise from the last portion of the contents of the FIR, my lord. Initially, when they were hired from Gulabganj, thereafter asked them to go to Arunachal Pradesh for work, and thereafter by putting them on fire, initially transferred some amount of money from their online transaction. Thereafter, my lord, while these persons were abducting on the
Then
way,
BDP.
yes,
party
BDP
came.
person, and then they shouted, and thereafter, my lord, 2 persons freed away and 1 person caught red.
No allegation against me, my lord.
No, but after snatching money also, you were participating, you were helping them.
No, my lord.
And
My lord,
then
my
when-
facts, my lord, will kindly para 4 and 5.
No, but FIR says that
Yes.
when FIR allegations are made against you.
With regard to the second vehicle, even if you go by the FIR, my lord, I was never driving this AS07V1477. I was driving this vehicle, AS07X5625. I was driving this vehicle. My lord, my facts and FIR facts may be different. Even if we go by the facts narrated in the FIR, I never drove this vehicle, my lord.
Okay.
I drove this
This
vehicle.
1477 was not driven by you.
No, my lord. Even if you go by the FIR, my lord, at 8 p.m., Bolero so-and-so took us to, after the Abdul Sadek told us
But,
to wait.
but you might not be driving.
No, I was not at all there. When the
No,
quarrel took place,
but the allegation is that you also fled away from the scene. Last line,
Yes, 1 and 3 fled from the.
1
scene.
and 3.
He is the
in
3.
fact, the VDP, my lord, directed me, since said that you are a driver, you go.
But
Because-
if you are not driving the vehicle, how
My lord, facts are, my lord, I
case
must.
diary, therefore case
I
diary
must
would,
confess before your lordships, the facts that I got from my client is different, and the facts narrated in the FIR is different.
different.
Why
Therefore,
I'm saying
case
so?
diary is necessary.
So kindly some protection, my lord. I'll cooperate with the
Now
investigation.
we are fixing short date because this is a case of dacoity.
There was no involvement of the petition.
Let us see.
The main
Heard-
accused 1 and 2, they are both arrested, my lord.
Heard
They are
Mr.
behind bars.
Heard Mr. H.K. Das. Their statement would be there. Heard Mr. H.K.
Yes.
Das, learned counsel for the petitioner. Also heard Mr. P. Bothakur, learned additional public prosecutor. Considering the nature of allegations leveled in the FIR against the petitioner, perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence, call for the case diary. Fixing
On 18/9.
18/9 for case diary. Let the case diary come.
Some protection. Much of this.
I'm sorry. Because it's another, I may allow to withdraw it.
Heard Mr. What is your name?
M.U. Ahmed.
M.U. Ahmed, learned counsel for the petitioner who prays for allowing the petitioner to withdraw the instant bail application. Prayer is allowed. This bail application is dismissed on withdrawal.
Obliged.
Please, lordship. My lord, 46, my lord, behind the bar, lordship.
13, my lord, charge sheet submitted, my lord.
Your lordship can, my lord, consider bail application, lordship.
What is the offense?
My lord, this is a fake currency, my lord. Allegedly, my lord, 13 fake currency were recovered from the house of the, from his maternal.
You appear before the trial court.
Mother-in-law's house, lordship.
Pray before the trial court. Heard Mr.
M.H. Ahmed, lordship.
M.H. Ahmed, learned counsel for the petitioner. Also heard Mr. P. Bothakur, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number. What is the charge sheet number?
Here date mentioned, but my lord, charge sheet number not in the CS. Thereafter, my lord, under section mentioned the charge sheet. So, my lord, I will get the after.
What I am submitting, lordship. and
Charge sheet
my lord,
submitted, my lord.
Can consider.
Charge sheet number dash.
In charge sheet.
Dash. Considering the fact that charge sheet has been laid,
Yes.
this bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before the said court, if so advised.
Lordship. I think 14, always.
May I please watch? FIR was lodged by wife and husband is behind the bar for last 52 days. A translated copy of the FIR is at page lordship 10. All are absurd allegations against the husband. They solemnized their marriage on 12 March 2024. Thereafter, the wife and husband resided
What is 318?
12-3.
318 BNS,
Lordship,
318. What is the offense?
or 318. 318 is cheating, Lordship. Cheating.
Cheating. 64,
64 is rape, my lord.
rape.
And
He says
64 is rape. 89 is miscarriage without
who
consent.
was raped?
Lordship,
You are saying that victim is the wife of the,
yes, Lordship. They have solemnized their marriage on 12th of March. They had love relations. And in a very small arrangement, they solemnized their marriage, Lordship.
This person was also arrested, my lord.
Nothing recovered.
No,
Recovered.
definitely, my lord. The recovery has already been made from the Sahabul Islam. my lord.
Because he's a
Recovery
allegation.
already been made.
no, apart from the statement of Sahabul,
my lord.
whether any other incriminating material is there.
Other incriminating material, my lord, that will lordship will go for the, my lord, this forwarding report, my lord. Forwarding report is page 18, my lord. Lordship may kindly see page 18. Page 18, my lord, clause number 9, my lord. Then lordship may kindly peruse. This is the other material, my lord.
Yes, not against this petitioner, Mofidul Islam. Mofidul Islam Muhammad, that is, was earlier arrested in connection with the North Lothimpur.
Who are you?
Lordship, Mofidul Islam is arrested some other cases, Lordship, for that. Mofidul Islam, Lordship, arrested some other case, not in this case, Lordship.
So you
Then-
have, okay.
This is the, my lord, he is also involved in this kind of cases, my lord. This is the
That-
humble submission, my lord.
Okay.
That was,
Investigation is still
that
going on.
matter was not settled, Lordship, that was under investigation, Lordship.
What is the period of detention for
My lord,
which?
51 days, my lord, today.
No, otherwise, how many days? 90 days offense or
My
60 days
lord,
offense?
that I have to, my lord.
Lordship, if recovery loss, then 90 days Lordship, fake currency is there, but fake currency part is not there against this petitioner, Lordship. Neither fake gold, not fake currency, Lordship. A mere statement of the co-accused, Lordship, who was arrested, Lordship, just to shift the burden, Lordship.
Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. R.J. Borwa, learned additional public prosecutor. This application under section 483 of BNSS, 23 has been filed by the petitioner Muhammad Mofidul Islam, who has been detained behind the bars since 22/7/2024 within bracket for last 50 days. in
51
con-
days, my lord.
51 days in connection with North Lakhimpur PS case number 195/2024 under section 61 within bracket 2/318 within bracket 4/179/180/112 of the Bharatiya Nagrik Sanhita, 2024-23. Stop. The gist of accusation in this case is that on 21/7/2024, one Bitupan Gogoi had lodged an FIR before the officer in charge of North Lakhimpur Police Station, inter alia, alleging that after receiving an credible information through secret sources, a search operation was conducted at village Pub Pandhua, North Lakhimpur, and one boat-shaped fake gold, one boat of fake gold, along with 610 suspected 500 rupees note, fake 500 rupees note, were recovered from one Muhammad Sahabul Islam. Stop. The said Sahabul Islam was arrested, and during interrogation, he disclosed that he had received the said seized materials from the present petitioner. Stop. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR Stop. And nothing was recovered from his possession. Stop. It is also submitted by learned counsel for the petitioner that petitioner has been arrested only on the basis of mere suspicion. He has also submitted that the petitioner has been languishing behind the bars for last 50 days, 51 days. And considering the length of detention, the petitioner may be allowed to go on bail. He also submits that petitioner is ready to cooperate with the investigating officer. Stop. On the other hand, learned additional public prosecutor has opposed the grant of bail to the petitioner on the ground that the co-accused from whose possession the fake Indian currencies were recovered has implicated the petitioner in his statement. Stop. Moreover, the petitioner, moreover, it was also found that the petitioner is also, where is the forwarding page?
Page 17 or
18.
17 is forwarding report, 18 is the relevant allegation against the petitioner.
Similar cases, earlier involved in similar cases, and was also arrested in.
And the offense is similar in nature.
North Lakhimpur PS case number 557/2022, as well as North Lakhimpur PS case number 192/2023. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the case diary of North Lakhimpur PS case number. What is the case number? 195/2024. Stop. It appears that the petitioner has been detained behind the bars for last 51 days. And at this stage, apart from the statement of the co-accused Shahabul Islam, there is no other incriminating material against the petitioner on record. Stop. Considering the above facts, his further custodial detention does not appear to be justified. Stop. In view of above, the petitioner, namely Muhammad Mofidul Islam, is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Lakhimpur, with following conditions. Condition number 1 and 2. With above observation, this bail application is disposed of. Send back the case diary.
Highly obliged, obliged.
May I please your lord? My lord, 483 application, my lord. Petitioner is a lady teacher, my lord. Behind the bar about 37 days, my lord. FIR at page 11, my lord. Sorry, my lord, 10. In brief, my lord, the accusation against the petitioner, my lord.
Yes.
The accused petitioner tutoring the children of the informant, my lord. And during the tuition period, my lord, she used to provide Mirinda, chocolate, bundia, laddu, etc. without their information, without the information of the parents. On the day of the alleged incidents, my lord, it is alleged that she provides some tablets to the children, and out of that, two children, one started vomiting and another is urine. And immediately she took to the nearest hospital, my lord, after their complaint, my lord. And thereafter, my lord, the nearest hospital referred to the GMCH. And GFC, after proper treatment, my lord, preliminary investigation, on the same day, my lord, they were discharged, my lord.
What is 123 of BNS?
My lord, that is causing
320.
causing heart by means of poison, etc.
Okay.
Up to extent of 10 years, I mean 37 days, my lord. And nothing poison, my lord. Had there been any intention, my lord, to causing the heart, my
What
lord?
is there in the case diary? Do you need further detention?
Yes, my lord, but allegation made in the, my lord, in the FIR as well as the, my lord, the statement of the other witnesses was very serious in nature, my lord. My lord, at present, my lord, the FSL report is pending, my lord. That is very important, my lord. Actually, what does it contain in the tablet, my lord? That is very much
No,
required, my lord.
why this was intentionally given?
Yes, my lord, intentionally given, my lord. They become unconscious, my lord. Somebody vomited, my lord. She being a tuition teacher, my lord, all the students, my lord, they are aged about 14 years, 13 years, my lord. She gave those medicine, my lord, tablets, my lord. After that, they become unconscious. They started vomiting, my lord. Without informing the parents, my lord, she took her to the nearest hospital. After that, my lord, the hospital referred them to GMCS, my lord.
And on
At
the
this
same
stage,
day,
my lord, I am opposing this bail application, my lord.
on the same day, my lord itself, my lord, they were discharged after proper preliminary investigation.
No, how can,
Actually,
my
my
lord,
lord-
how can, my lord, being a tuition teacher, my lord, he
Actually,
can
my lord-
give this medicine, my lord?
No medicine has been provided, my lord. Had there been any intention, my lord, definitely she could not take to the nearest hospital, my lord.
Statements of the victims were recorded.
Yes, my lord, 160% is there, my lord.
Students,
Yes,
what they have stated.
my lord, Lordship, I'll just
Now
take-
why do you want her detention?
Because, my lord, it is very much necessary to know actually what does it contain in the tablets, my lord, which was provided to the children, my lord. And what was actual intention, my lord, for providing those things, my lord, medicine, my lord.
No.
Whatever it is, medicine or tablet, my lord, whatever it is. It may contain, my lord, narcotics also, my lord.
What is her statement?
My lord, tuition teacher or the
What
student.
she has stated for last 37 days.
Lordship may kindly peruse, my lord. I have slightly 164 statement of the students, my lord, as well as the teacher also, my lord. Teacher said, my lord, they were feeling some weakness. That is why she has provided this vitamins, my lord.
Vitamin.
Vitamins. If it is
Okay.
a really vitamins, my lord, if somebody will get, my lord, unconscious or start vomiting, definitely not, my lord.
Okay.
It is
But it is pending forensic report.
pending a forensic report, that is very important, my lord. That is why I am opposing, my lord. Otherwise, I would have not opposed.
No, but why her detention is necessary now? We'll ask her
My lord,
to.
if, my lord, intentionally CS provides some, my lord, narcotics, my lord, it may contain narcotics also, my lord. Then why she will provide, my lord? These are all small children, my lord.
The tablets were seized.
Yes. That is why it is sent for assessment.
Yes.
My lord, further custodial detention may not require, my lord. My lord, last occasion this matter had come up, my lord. Perhaps some witnesses also stated that the vitamin tablets were, they suspected that that is a vitamin tablet, my lord. And she is suffering from nerve disease, my lord. And I have also explained mentioned in my petition, my lord. 37 days behind the bar, my lord. Had there been any intention, my lord, definitely she could not took the students to the nearest hospital. Thereafter, my lord, after informing GMCH, my lord, and GMCH on the same day, my lord, after proper treatment, my lord, all the children were after proper treatment discharged from the hospital on the same day, my lord.
Heard Mr. A. Jain, learned counsel for the petitioner. Also heard Mr. R. J. Burwa, learned additional public prosecutor. S.K. Jain.
SK Jain,
Sorry.
my lord.
Heard Mr. S.K. Jain, learned counsel for the petitioner. Also heard Mr. R. J. Burwa. This application under section 483 of BNSS, 2023 has been filed by the petitioner Lina Kalita alias Momi Kalita, who has been detained behind the bars since 4/8/2024 within bracket for last 37 days in connection with North Guwahati PS case number 109/2024 under section 123 of BNS 2023. The gist of accusation in this case is that on 2/8/2024, one Srimati Hima Das had lodged an FIR before the officer in charge of Amingaon Police Station, inter alia, alleging that the petitioner used to give tuition to the children of the informant and some other children at her residence at Trinayan Nagar under North Guwahati Police Station in Kamrup district. It is alleged that the petitioner used to provide Mirinda within inverted comma Singara within inverted comma Bundia Laddu and chocolate for the children, to the children whom she used to tutor. It is also alleged that on 31/7/2024, she gave some tablets to some of the students, some of the children's, and after eating the said tablets, the children started vomiting and urinating and became weak. The petitioner thereafter took them to Tolaram Bafna Hospital without informing their parents. From there, it is also stated in the FIR that from there, the children were taken to GMCH for proper treatment. So, learned counsel for the petitioner has submitted that the petitioner has not committed any offense and she had bona fidely provided the vitamin tablets and other eat food to the tuition to the children whom she was tutoring. So it is also submitted by learned counsel for the petitioner that when some of the children fell sick after taking the tablet, it was the petitioner who immediately took them to the hospital, and had she had any malafide intention, she would not have done so. Stop. Learned counsel for the petitioner has also submitted that the petitioner, being a lady, has been detained behind the bar for last 37 days, and considering the long period of detention, she may be allowed to go on bail. He also submits that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of North Guwahati PS case number 109/2024 and has vehemently opposed the grant of bail to the petitioner on the ground that the petitioner intentionally gave tablets to the to the children whom she was tutoring without informing the same to their parents. He submits that, then an additional public prosecutor also submits that though the statement of the victim students are recorded under section 183 of BNSS, 2023. However, the forensic report of the tablet seized in this case is yet not received. He also submits that there is a probability that the tablets may be narcotic drug and psychotropic substances, and therefore unless the forensic report is received, the petitioner should not be allowed to go on bail. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials on record. It appears from record that on the date of incident, when the student/victims fell sick by consuming the tablet, it was the petitioner who herself took them to the hospital first. Stop. It also appears from record that the investigation of this case has fairly progressed and the investigating officer has recorded the statement of victim children as well as the complainant, and the case is pending only for receipt of forensic laboratory report. Stop. The apprehension showed by learned additional public prosecutor that the tablets may also be narcotic drugs or psychotropic substance, at this stage does not have any basis, except it only appears to be suspicion at this stage. Considering the petitioner being a woman is entitled to get special treatment while considering a bail application. Moreover, she has been detained behind the bars for last 37 days. Stop. Considering the period of detention as well as progress of the investigation, this court is of considered opinion that further custodial detention of the petitioner may not be necessary for fair completion of investigation of North Guwahati PS case number 109/2024, if the petitioner cooperates with the investigating officer. Stop. In view of above, the petitioner is allowed to, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Kamrup Amin Gao. This bail application is accordingly disposed of. Send back the case direct.
Highly obliged.
I'm taking a short. Counsel for the petitioner. Also heard Mr. R.J. Burwa, an additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
290/2024, dated 31/8/2024.
In view of the fact of laying of charge sheet, this bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before the said court, if so advised.
Yes, your lordship. Lordship, it's a regular bill, CD receipt. Has they received, my lord? My lord, allegation is cheating by personation, kidnap, and seduced to illicit intercourse, and criminal conspiracy. My lord, FIR is translated page number 8 and vernacular, page number 10. My lord, allegation is, my lord, one.
When were you arrested?
70 days, my lord, already detained, and 69 days indeed.
What is the
behind the bar.
date of arrest?
Date of arrest 2/7/2014 and forwarded next day 3/7/2014. 24.
Yes. Where is the FIR?
Your Honor, the allegation is cheating by personation. The one Vikram Khan developed a relationship with the victim, Himati Khan. She's major and 18 years. Your Honors, your Lordship,
Okay.
and my Lord, I have written in paragraph 5, my lord, clearly. My lord, well, the petitioner has not committed the alleged offense. He has
False allegation.
he has been falsely only to harass him. The actual fact of the case is last 6-7 months, the petitioner and the victim developed a relationship, and they have often used to go for date. The victim visited the house of the petitioner several times, and having complete knowledge about the petitioner, and planned to get married with the petitioner. The matter, the mother of the victim was not agree in the intercaste marriage. Having no alternative, she planned to run away for Bangalore secretly to marry with the petitioner. But the railway police detained on suspicion from Bongaigaon railway station and handed over the Sadgaon police. The family member and the local people become furious, and pressure created on her, and hence she lost the FIR. Well, let's say victim, my lord, the victim is in love with him, and often used to go for date, and complete
Yes.
knowledge.
Yes,
And
Mr.
she's
Bolu.
major.
My lord, we have received the case diary, my lord. This person, my lord, accused person, his name is actually Vikram Khan, my lord. But he's identified as a Vikram Das, my lord. And he, my lord, influenced the, my lord, victim girl, my lord. And my lord, he initially took her to different places, my lord. Indulged in physical activity, relation, my lord. By impersonating him as a Vikram Das, my lord. This is the allegation. And he tried to, my lord, play the victim, my lord, to Bangalore, my lord, then police arrested him.
At that time, FIR was not lodged.
No,
No, my lord, when she was missing from home, my lord, then my lord, FIR was lodged.
After-
That is why they were arrested, my lord, when they were planning to go, my lord, Bangalore, my lord.
after 5
But
days. my
victim
lord.
guard, my lord, they have implicated him, my lord, with CS in her 160.
Now, whether his retention is required.
The allegations are very serious, my lord. Impersonating him as a, my lord. He's actually a Muslim guy, my lord. But
Neither
identify him as a, my lord, Hindu, my lord. That is why, my lord, the guard, my lord, she thought that he is a Hindu boy, my lord. She will love her. And that is why she fallen into love with him.
What she has stated in her statement. No, facts I have understood.
Yes.
That a Muslim boy impersonated himself as a Hindu boy. And
from initial stage, my lord.
now,
he identified-
because 70 days, he's behind the bar for last 70 days.
70 days.
Now whether detention is required.
The investigation
is
is still pending, my lord. It was pending to collect the, my lord, FSL report, my lord, because the residence swab and etc., my lord, that has been seized.
But for that, whether his detention is.
The allegations are serious, my lord. It is why I am.
Investigation complete, further decision may
The
not.
investigation is not complete.
No, is there any,
There are still times to
Madam,
complete the investigation. my
She is in, victim is in love, she is major, she is
lord. No,
consented.
she is in love. She has consented because she thought that he is a, my lord, he is Vikram Das, not Vikram Khan, my lord.
What
During
is-
these
That is
5
why,
days-
that is why, my lord, she fallen into love.
My lord, during these
What-
5 days, she was not in house.
what
Neither
what
mother
she has stated in her
Not any missing complaint.
183 statement.
My lord, I am just reading one statement, my lord. তেওঁ বিক্ৰম দাস বুলি মোক নিজৰ চিনাকি দিছিল লাহে লাহে
And
আমাৰ
that
মাজত
is the
ভাৱ
main
খোৱা-
allegation, that
Yes.
is the charge.
That is why, my lord, she fallen into love, my lord. That is why she was ready to go
What
with him.
later on, what she says.
After that, my lord, he took her to different places in Assam, my lord.
And cheating by personation
Yeah,
is.
ultimately, my lord, they eloped, my lord.
They love, that is the fact, my lord. Knowingly alone. To get married.
No, knowingly, not knowingly, my lord.
There is no force, my lord. She is in love. The victim is
No,
in
but
love, she
deceit is
major.
there, no, often. Prima facie, it appears that you are guilty of deceit. Now there is an offense. New offense is there. By deceit, if you indulge in sexual intercourse, that itself is an offense. So materials are there against you. But whether custodial detention is necessary.
My lord, let this matter come after 10 days alone. We'll call for the FSL report, my lord. If it is not come, my lord.
My lord,
Lordship may
70 days.
consider. No, still there are times to complete the investigation, my lord. Statute has provided.
He is looking for no chance of absconding, no.
No,
hamper and
10 days,
temper.
10 days are,
Why is? My lord. My lord, humble submission, my lord, no further decision.
Let it come, my lord, on today's
Kindly
date, my
allow,
lord.
17 days already, my lord.
Let it come on 20, my lord.
why?
My lord, to well get the, my lord, FSL report. My lord.
My lord, not necessary. Further, decision not necessary. Only say, already 70 days passed, my lord.
We will, I am directing him to appear before the police station. Till 90 days gets over. Every week he will appear before the police station. Heard, Mr.
And my lord, he will not, my lord, hit on the victim. my lord.
Yes. Heard, Mr. What is your name?
T. Mohammed.
Heard, Mr. T. Mohammed, learned counsel for the petitioner. Also heard Mr. R.J. Bora, learned additional public prosecutor. This application under section 483 of BNSS, 2023 has been filed by the petitioner, namely Bikram Khan, who is aged about 20 years and who has been detained behind the bars since 3/7/2024. How many days exactly?
69 days behind the bar.
Within bracket for last 69.
70 days, my lord.
For last 70 days in connection with Sadhgao PS case number 101/2024 under section 319/319 within bracket 2/87/61 within bracket 1 of BNS. The gist of accusation against the petitioner in this case is that on 3/7/2024, the victim lodged an FIR before the victim girl lodged an FIR before the officer in charge of Sadhgao police station, inter alia, alleging that the petitioner impersonating himself to be Vikram Das and belonging to Hindu community, developed a relationship with the victim girl for last 6 months. And on 30/6/2024, no, give me the statement of the victim
Yes,
girl. On 30/6/2024, the petitioner subjected her to forceful sexual intercourse. And on next day, in order to take her to Bangalore, no, on the next day, the petitioner took her to Bongaigaon by train and stayed in a hotel at Bongaigaon for night, on that night. And on that night also, she was subjected to forcible sexual intercourse. No, in both the FIR as well as statement, she has stated that she was subjected to forcible sexual intercourse.
that is what. It was not voluntary.
It is not only out of love, not only deception.
She went her own, she is measure, fully consented.
The consent part is not there, madam, in the 164.
She.
Forcible sexual intercourse. Learned, stop. Learned counsel for the petitioner has submitted that the petitioner as well as victim had a romantic relationship and the affair with the petitioner, affair with the victim was consensual in nature. Stop. He also submits that the petitioner has been detained behind the bar for last 70 days. And therefore, considering the nature, considering the length of detention, the petitioner may be allowed to go on bail. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the victim girl on the ground that the victim girl was deceived by the petitioner by concealing his real identity. And it also appears that he also submits that the nature of allegation made against the petitioner is heinous, as the victim was subjected to forceful sexual intercourse, which forceful sexual intercourse. Stop. Learned additional public prosecutor also submits that the forensic report,
Of the minor, the swab and all this.
the forensic report in respect of the swab collected from the victim girl has not yet been received by the investigating officer. He also submits that there is also a possibility of threatening the victim girl by the petitioner if he is released on bail, and therefore opposes the grant of bail to the petitioner. I have considered the submissions made by learned counsel for both the sides and peruse the material in the case diary. It appears that though there was a romantic relationship between the victim girl and the petitioner, however, same was due to the deception by the petitioner. Stop. It also appears from the case diary, from the statement of the victim girl, that she was subjected to forceful sexual intercourse by the petitioner. Considering the fact that the victim girl was subjected to forceful sexual intercourse by the petitioner, what is the age of victim girl?
18 years. my lord.
Forceful sexual intercourse by the petitioner. This court is not inclined to grant bail
My
at
lord,
this stage.
Considering the duration.
The prayer for bail is therefore rejected at this stage. Send back the case diary.
May I please watch this, my lord, 483 petition, my lord, regular bill, my lord.
Sorry, my lord, CD not received.
In this case, my lord, kindly have a look at page 10, my lord. It's a vernacular, my lord, FIR, my lord, page 10. In this case, my lord, this admittedly, my lord, the alleged victim, she's a married lady, my lord, and FIR has been lost by her husband, my lord. Kindly see, may I read, my lord?
Page 10.
Page 10, my lord, yes. Page
Yes.
number 10, my lord. Say, সন্মানপূর্বক বিনীত নিবেদন এই যে মই টংলা থানার অন্তর্গত হাহিনী গাঁৱৰ নিবাসী শ্রী অজিত বড়ো আজি 13/8/2024
What is 64(1) BNS?
Yes, my lord, that is, my lord,
64 is rape, my lord.
rape. Yes, my lord. But in the FIR itself, my lord, you kindly see, দিনৰ 2:30 বজাত মোৰ পত্নী শ্ৰীমতী মিনতি copy was called for, my lord. I have, my lord, the certificate copies of all orders, my lord, along with the, my lord, statement of the PW 1, 2, and 3. And the
We have
court-
to go through, my lord.
So far, my lord, the facts of the case is such. In connection with the affair dated 18/7/13, petitioners, both the petitioners were arrested along with some other persons.
Maybe at two,
Now,
my
my
lord,
lord,
then.
Let him go through. Let him go through this. We'll take it up in the second half.
Yes, yes. With all respect to senior my lord, it's my lord, R.J. Boru has gone through the case. There, my lord, he put number 24, 26 is called for, my lord.
That's it, I'll wait.
After some time, my lord, he will come, my lord.
Where is the I'm an interim, my lord, the CD was called from.
Case diary is there.
Yes,
He has appeared.
my lord, yeah, appearance regarding him, my lord. His statement. Yes, it is honest.
That's August of the interim.
Mhm.
That's August interim, that's absolutely.
No, his diary is not up to date, my lord.
Last occasion, the updated diary was called from.
Diary is
My
not
instruction,
updated.
bail appeared, man.
And you are on bail.
Yes,
You
please.
took bail.
Up to
After
June, my lord.
appearance, you took bail
Yes,
from,
ma'am.
you are allowed to go on bail.
Yes.
That bail documents have to be in the case diary.
My lord, no, my lord,
Bail bonds.
nothing, my lord. It has to be up to date. Diary is up to June, my lord. 20th
Okay, heard Mr. N. Mahajan, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor, who submits that the case diary, though the case diary is available before the court, however, same is not updated, and an updated case diary would be required for consideration of this
Granted
bail.
interim on 7th of August, that is only till June.
Okay. Let an updated case diary be called for. Fix this matter again on
my lord, next. On 19, my lord.
19 September. Till then, the interim order shall continue.
Obliged.
May I please your lord. My lord, anticipatory bail application offense under section 302, my lord. Three accused persons are there. Accused number 1, my lord, already given interim relief, my lord. FIR, my lord, on page number 13, my lord. May I read the FIR, my lord?
Yes.
Complainant Prasanna Ghorali, accused person Samsul Ali, Noor Iman, and others. Most respectfully beg to state that on 24/6/2024 at around 8 p.m., while my friend Gautam Daka and I were returning home from Bangsar at a place namely Monpara Rajghat, we fell from the bike upon hitting by a strong beam of light of a heavy vehicle from the front side, and as a result, our vehicle touched a person standing nearby. There were many other people present at the place of occurrence. The people started beating us both without questioning us. I was coming on my bike bearing registration number so and so. The people started assaulting us mercilessly on various parts of our bodies, causing serious injuries to both of us. The accused person assaulted us and handed over us to Hazu police station. The police released us around 2 a.m. Though both of us returned to our home, but as the condition of my friend Gautam Deka was very critical, he was first taken to Swalkusi Civil Hospital and later on referred to GMCH. But yesterday on 26/6/2024 at about 11 a.m., he succumbed to his injuries. There is a delay of lodging the affair as we were busy in as well as my treatment of my friend Gautam Deka. This is the affair, my lord. And my humble submission is that all the statement in the affair are true, my lord, but we are not involved. The victim, my lord, and the informant. The accident occurred and I was injured, my lord. I am Noor Imam Malik. And thereafter, my lord.
You were hit by
I was
motorcycle.
hit by, my lord, motorcycle driven by this informant and the victim, my lord. I was hit.
I means out of
My
three
lord,
home.
my lord, Noor Imam, my lord, petitioner number 1.
And other two?
Other two, my son and son-in-law, my lord. We lost the affair also, my lord. Kindly see the affair, my lord.
No. We will not go to that affair.
My lord.
The son and son-in-law, whether they beat the
Yes, Lordship. Nuriman was hit by the informant vehicle, Lordship, and the motorcycle, and son-in-law, and the eyewitnesses are there, Lordship. They have implicated that yes, they were present on the spot and they have beaten up by the informants. And subsequently, the later part of day, the other victim was dead, Lordship.
As per my instruction, my lord, the victim and the informant was assaulted. That is true, my lord. But not by this accused person and not so seriously as was alleged in the affair.
Lots of people should get out of there. Lots of people.
many
should
other people
Many other
were-
people are there. And, among them, this.
So this is not a case for anticipatory bail, at least to petitioner number 2 and 3.
Lordship.
Petitioner number 1, we are making it absolute and rejecting other 2. Heard. So, witnesses have named
Yes,
named
name.
Noor Ahmed and Kamal Ali, and named others also.
Not others,
Only 2.
only 2. Lordship, many son-in-law, Zwag, it means Zwag, but later part the Zwag is Kamal Ali, Lordship. That is implicated, Lordship. But if PM report is available, that may be reduced for a moment, my lord, if the cause of death, as per my instruction, my lord.
Heard, Mr. What is your
R.
name?
Sharma, my lord.
R. Sharma, learned counsel for the petitioner. Also heard Mr.
DP Goswami.
D.
DP Goswami.
D.P. Goswami, learned additional public prosecutor. This application under section 482 of the BNSS, 2023 has been filed by the petitioners, namely Noor Iman Ali, number 2, Noor Ahmad Ali, and Kamal Ali. Apprehending their arrests in connection with Hajo PS case number 222/2024 under section 325/307/302/34 of the Indian Penal Code. The gist of accusation in this case is that why you lodged FIR
My lord, regarding the accident, my lord.
by
That
accident?
was rash and negligent driving, my lord. We first lodged the FIR, my lord. We handed over the victim to the police also. my lord.
FIR against Prasanna Bharali.
My lord.
Okay. The gist of accusation in this case is that on 27/6/2024, one Prasanna Bharali had lodged an FIR against the petitioner number 1 and petitioner number 2, naming petitioner number 1 and petitioner number 2 therein, inter alia, stating that on 24/6/2024 at about 8 p.m. when the informant was returning home from Bangshar along with his friend Gautam Deka, one bike hit them, causing no, not one bike. Their bike hit a क्या लिखा अलग चेंज करने on a motorcycle. At that time, a heavy vehicle coming from the other side put the beam of their its headlight in front of the informant, as a result of which the motorcycle fell down and a person standing nearby got injured. At that time, it is also stated in the FIR that the people who gathered there started assaulting the informant as well as his friend, as a result of which the friend of the informant, namely Gautam Deka, sustained severe injuries, and he was referred to Guwahati Medical College Hospital. And on next day, that is on 26/6/2024, Gautam Deka succumbed to his injuries. Stop. Learned counsel for the petitioner has submitted that the petitioners are not involved in the incident of assaulting the informant as well as Gautam Dekar. He submits that Noor Iman Ali himself suffered injuries in the motorcycle accident, and Noor Ahmad Ali, who is the son of the petitioner number 1, and Kamal Ali, who is the son-in-law of the petitioner number 1, were not involved in the assault. He submits that the petitioner number 1 has already been granted interim protection, interim bail by this court, and he has not misused his liberty on bail, and therefore prays for making the bail absolute, and also prays for granting the other 2 petitioner anticipatory bail. Stop. On the other hand, Mr. D.P. Goswami, learned counsel for the learned additional public prosecutor, has produced the case diary of Hajo PS case number 222/2024 and has submitted that there are sufficient incriminating materials against petitioner number 2 and 3 of having assaulted the deceased. This is namely Gautam Dekar. He submits that, and therefore he opposes the grant of anticipatory bail to the said petitioners. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials on record, including the case diary produced by learned additional additional public prosecutor. Stop. There are sufficient incriminating materials against petitioner number 1, petitioner number 2, Noor Ahmad Ali and Kamal Ali in the case diary, which does not justify grant of anticipatory bail to them at this stage. Hence, their prayer for anticipatory bail is hereby rejected. However, the petitioner number 1, Noor Iman Ali, himself got injured in the accident and he has not assaulted.
Not assaulted.
And there is no evidence of his being involved in the assault of the deceased person. Stop. Therefore, the interim anticipatory bail granted to the petitioner number 1, Noor Iman Ali, on 29/7/2024 by this court is hereby made absolute with condition number 2, 3, 4 attached to the said order remaining intact. This bail application, anticipatory bail application, is accordingly disposed of.
Obliged.
Very. This is for 30 repetition, kindly see annexure 1 minute azhar, page 10 minutes.
What is the offense?
302 minutes.
302.
Well. Here in the fact in simple milord, I am the milord labor, I am the master milord, I work in Odasal project. In the meantime, milord, my wife and
What is your name?
my name is milord Mahibur Ali.
Mohibur. Mohibur.
Mohibur Ali, actually, my name Mohibur Rahman, my name, but they have mentioned Mohibur Ali. But I
Who died? Your wife died.
Wife.
Okay.
At the time, I was not at home, milord. And the other family members, they have also filed bail petition, they also accused milord, and they have been granted anticipatory bail, milord. And at the time I was not there, I have not filed that, so I filed subsequently, my lord. And at the relevant point of time, Lord, I was in Arunachal Pradesh, I have mentioned in my petition, my lord. And first we kindly see annexer one as our, my lord. Made in, my lord. With due respect, I will state that around 3 years back, I got my daughter, Nitish Parveen, married to Mohibur Rahman of Ambari village in a social ceremony, but after her marriage, her in-laws began.
Is it a suicide or
Yes,
suicide? Hanging,
hanging is there, but there are something, non-continuous ligation mark. That is there as per the postmortem report, death was due to asphyxia as a result of antemortal hanging, which was suicidal in nature.
suicidal in nature.
Suicidal in nature. But there are some injury on the face. The injury sustained on the face was antemortem caused by blunt force impact and was simple in nature. There are something. My lord, I was in the on earlier date in a coordinate bench as a handler in the other family members, father-in-law, mother-in-law, and all these, my lord. Several persons were there. On that night, my lord, other persons went to a my lord, village some functions at night. The lady was in the house. My lord, in that room, she and his and her minor daughter around 2.5 years, and another girl of his sister-in-law. She is 7 years. In the morning, when she didn't wake up, my lord, mother-in-law, when knocked the door, she heard that someone is crying inside. Then they knocked the door opened by the 7-year-old girl, sister-in-law, sorry. Then also saw that she is hanging by a string in the ceiling fan. Now, one fact is that, yes, other person around in the evening itself, they went to the village function and came in the midnight. Now, his case is that he is not at that time, he is in Arunachal Pradesh. But that is not there. He was also there as per the statement of the father-in-law, his father. He was there. He also went to the village, that function lately. He went around 8 p.m.
On that day.
On that day. He went around 8 p.m. and came earlier. But when he came and what happened, that much is not available in the case. That is. Now, statement of the dead two girls.
7 years old.
That girl is also not available. That is vital, Malak. Her girl is very small, 2.5 years, around 3.
She's not in a position to talk.
7 years old girl.
Not a small one. My petitioner's daughter-in-law.
She's around 3 years. She's around 3 years. But that 7-year-old girl's statement is also not available. But only one thing is that he stated that he was not there. As per the petitioner's statement in the petition also, he was not there. I am reading statement of father. Father. Mohiruddin lagi. Answer me. No, that's very
Answer Ali. Answer Ali.
Otherwise, as per the statement of the his father, his father-in-law, he stated that with love relation, that marriage was happened 4 years earlier, and there are conflict between the other family members of the house. Well, on that night, but other family members were not available. But my thing is that injury in the face, that is also in the.
There is a conflict with other family members, not with me.
That implies.
No, other family members were not there. They went.
No, but whether the petitioner was there or not, anything to show that
Yes, yes, yes.
petitioner was there.
And from the Azhar itself, from the face of the Azhar, Lord, there is no indication that I was there. Even my father-in-law lost the Azhar, Lord, nowhere mentioned that I was there. Only Lord, her in-laws began to torturing her.
Answer Ali is the father, father of the petitioner.
Yes, father.
মোৰ যোৱা ইমান তাৰিখে শনিবাৰে আমাৰ আমবাৰী ধৰ্মসভা আছিল মোৰ ৱাইফ চাকিতন নেছা ৰাতি 7 মান বজাতে ধৰ্মসভালৈ গৈছিল আমাৰ ল'ৰা মহিৰুদ্দিন সি ৰাতি 8 মান বজাত ধৰ্মসভালৈ গৈছিল so if he is in Arunachal Pradesh the statement of the father his father so idul মোৰ ল'ৰা আৰু তাৰ ঘনীয়েকৰ
So
ধৰ্মসভালৈ
this is not a fit case for 482. Why you are telling?
only two things Malat I am
Because petitioner is not speaking truth. Either petitioner is telling lie or his father is telling lie.
Either, Lord,
Either.
either.
So father does not have any reason to.
Malat in the other petition also I am sending is
No, but what is
all
I
are
am
inside and
instructing, Lord, so
but regarding some injury, some may be there, my lord, in that night when other members were not there, and because of that, my lord, she may commit suicide, but may not be 302. But
May not be 302. Let
may
him
not
appear then let him appear. If you find any
no
material against him.
he my lord, regarding his conduct, my lord, that he stated that in his petition also stated that he is not there. He went to Arunachal Pradesh. His father stated that Mohiruddin রাতে 8টা বজাত ধর্মসভালৈ গৈছিলে then my lord, these are conflicting, my lord. And
No, but how it implicates the.
that is not clear. My lord, statement of that
There is a doubt that
girl,
he might be involved.
statement of that girl is very necessary. That is not available.
And the death occurred about 5 months ago.
my Lord. That
So
was in
till
the
now,
month of 10th of
girl
9th of
being a minor girl, her statement should have been recorded at the earliest. Then let him appear because the death is otherwise suicidal in nature. If you find anything, pray for cancellation.
My lord.
Heard Mr. A. Rashid.
My objection maybe my lord.
Yes, heard Mr. A. Rashid, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of the BNSS, 2023 has been filed by the petitioner Mohibur Ali alias Mohibur Rahman, who is apprehending his arrest in connection with Abhayapuri PS case number 79/2024 under section 302/34 of the Indian Penal Code. The gist of accusation in this case is that on 10/3/2024, one Badaruddin had lodged an FIR before the officer in charge of Abhayapuri police station, Inter Alia, alleging that his daughter Bilkis Parveen, who was married to the present petitioner about 3 years prior to lodging of the FIR, was subjected to torture by her in-laws for demand of dowry. Stop. It is also stated, alleged in the FIR that on 10/3/2024, the petition, who is accused number one?
accused of petitioner.
The petitioner had hatched a petitioner along with the other accused persons had beaten up the daughter of the first informant and killed her by strangulating her by a scarf. Stop. It is also alleged in the affair that after killing the daughter of the first informant, the accused persons are trying to give the incident a color of suicide. Stop. Learned counsel for the petitioner has submitted that the petitioner is the husband of the deceased and was not at the place of occurrence when the incident occurred. Where were you?
I was in Arunachal River.
He submits that at that time petitioner was in Arunachal Pradesh for his livelihood. Stop. He has also submitted that in the meanwhile, the other co-accused persons have already been granted bail by which you have
In AB number 85624.
in AB number
85624.
856/24. All other
All.
856 of 2024. He submits that the petitioner is ready to cooperate in the investigation and therefore prays for allowing the petitioner to go on anticipatory bail. Stop. On the other hand, Mr. K.K. Parashar, learned additional public prosecutor, has vehemently opposed the grant of bail to the petitioner on the ground that though the post-mortem report of the deceased shows that the death of the deceased was by hanging and which is suicidal in nature. However, he submits that the postmortem report also mentions about some injuries on the face which were anti-mortem in nature. Stop. He also submits that at the time of the incident, minor daughter aged about 2 years of the 3 years of the petitioner, as well as another girl aged about 7 years, were there in the house where the incident had occurred.
In the room.
Inside the room where the incident had occurred. Stop. However, their statement is yet to be recorded. He also submits that the father of the petitioner, in his statement before the investigating officer, has stated that the petitioner was at that place, was in the village, that is Ambari village, on that day, and he went to attend
The
village function at about 8 p.m.
8 p.m.
And the petitioner, learned additional public prosecutor, therefore submits that as petitioner is taking a plea of
You have anything else?
petitioner is stating that he was not at the place of occurrence is contradicted by the statement of his own father, and therefore suspicion arises regarding his involvement in the alleged offense, and therefore he opposes the grant of bail to the present petitioner. Stop. I have considered the submissions made by learned counsel for both the sides, and have perused the materials available on record, including the case diary of Abhayapuri PS case number 79/2024. Stop. It appears that the incident occurred about 5 months back. However, the investigating officer has not yet recorded the statement of one of the vital witness, that is the 7-year-old girl who was present in the room at the time when the alleged offense was noticed by the others. Stop. Though there appears to be inconsistency in the statement of the father of the present petitioner, as well as statement made by the petitioner in this bail application, however, as postmortem report suggests that the death of the wife of the petitioner occurred due to suicidal hanging, this court is inclined to grant anticipatory bail to the petitioner at this stage. Stop. The above named petitioner is therefore directed to appear before the investigating officer of Abhayapuri PS case number 79/2024 within a period of 10 days from the date of this order and to cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with Abhayapuri PS case number 79/2024, the above named petitioner shall be allowed to go on bail of rupees 30,000 with one security of like amount, subject to the satisfaction of the arresting authority, with following conditions. Condition number 1 and 2. With above observation, this anticipatory bail application is hereby disposed of.
The 7-year-old girl is Saida Khatun, maybe in the
7-year-old girl, namely Shahida Khatun. Send back the case diary.
In the morning, I mentioned a matter listening for AB. Their lordship has put a question, is it less than or more than 7 years? I checked out, it was less than 7 years. I'm sorry for the.
Hear it now or
Should be, your lordship, here the bail matter, my lord.
other matters? No, whether your interlocutory application should be heard now.
Yes, my lord.
Mr. Bhattacharya is not there.
He will come, my lord. Will come 5 minutes, my lord.
How much time will you take? You will take more than 5 minutes.
More than 5 minutes. 5 minutes, my lord. Within 10 minutes, I will complete it, my lord.
Or we'll take it up after finishing bail matters, bail hearing, then we'll take it up.
Yes, sir.
Because it may take time, it appears.
Yes. Only thing, two thing, my lord.
Because NDP, Mr. Parashar, you are appearing. You are opposing.
As far OCP case is above 21 years age, and there are evidence is above 25, my lord, and transfer certificate of the school has been considered.
POXO matter, it is a
Yes, my lord.
POXO or NDPS.
Yes, my lord.
We'll take it up today
Yes,
after bail matters.
Yes, my lord.
After bail, before admission.
Yes, my lord.
Before taking admission matter, we will take it. Bail hack for what? So, before admission, bail hack for Pisok, Itya bail hearing to hack for.
No, maybe after some time, I'm not fully done from 59. After some time.
After some time.
Because I am continuously doing the
Okay.
other.
We'll take it up after some time.
Item 24.
May I please, your lordship, city is not there.
City not present, Lordship, is an interim.
Interim
Heard, Mr. What is your name?
S. Chaudhary.
A.S. Chaudhary, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor, who prays for some time for producing the case diary. Prayer is allowed. Let this matter be listed again on when?
25/9, Lordship.
25/9 for case diary. The interim order shall continue till next day.
Item 25. 25, Lordship, charge sheet submitted.
May it please,
You are on interim.
my lord, yes. My lord, may I pray that 2 weeks time may be given, this interim may be extended. In the meantime, I will appear before the trial court.
No, you appear before the trial court when the summons, you receive summons. Why? You wait for, I am making it absolute.
My lord, my lord, my lord.
Heard Mr. T.H. Hajorika, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor, who submits that though case diary was called for, however, in the meanwhile, charge sheet has already been laid, bearing charge sheet number
230/24, 230/24, dated 29/9/2024.
Stop. Learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail on 1/8/2024 with certain conditions. And in pursuant to the directions of this court, you appeared before
Yes, yes, my lord.
the petitioner has appeared before the investigating officer. Stop. And cooperated with him. Stop. In view of the submissions made by learned counsel for the petitioner, and in view of the laying of the charge sheet, the interim anticipatory bail granted to the petitioner on 1/8/2024 is hereby made absolute with condition number 2 and 3. With condition number 3 attached to the said order remaining intact. With above observation, this anticipatory bail is application is disposed of.
I'm deeply obliged, my lord.
Maybe. Lordship, in this case, Lordship, interim was granted, Lordship, and petitioner appeared before the IO. Now, Lordship, case 11 with the FIR, Lordship.
Has he appeared?
Here, from the appeared statement recorded.
What is your submission?
From the 160, your lordship may kindly please last
No.
portion of the.
No, I am not crazy.
Other he,
Interim,
uh,
interim,
she implicated, but otherwise in the last portion of the 164 statement, হজরতে মোৰ স্বামীৰ বিৰুদ্ধে এটা কেছ কৰাত সেই কেছত মোৰ স্বামী জেলত আছিল আজি কেইদিনমানৰ আগতে বাহিৰলৈ ওলাই আহিছে so earlier my lord one case was filed by the accused persons against the husband of the informant.
It is the result of process
his
filed by
statement has been recorded. Heard Mr.
Yes, sir.
S. Alam, learned counsel for the petitioner. Also heard Mr. K. Also heard Mr. P. Borthakur, learned additional public prosecutor, who has produced the case diary of Kazigaon PS case number 23/2024. Stop. He submits that though there are some incriminating material against the petitioner in the case diary, however, he submits that the petitioner has appeared before the investigating officer and his statement has been recorded under section 1/8.
376 is also.
No. What is the new section for 161?
These are earlier sections.
Section 142.
180, my lord.
180 of BNSS. Stop. Stop. I have perused the case diary and have heard and have considered the submissions made by learned counsel for both the sides. On perusal of the case diary, it appears that the petitioner has complied with the directions of this court, which were issued on 2/8/2024, while granting anticipatory bail to him. Stop. As the petitioner has complied with the directions of this court and has cooperated with the investigating officer, the interim anticipatory bail granted to him on 2/8/2024 by this court is hereby made absolute, with condition number 2, 3, and 4 attached to the said order remaining intact. With above observation, this anticipatory bail application is disposed of. Send back the case diary.
Item 27. Now on interim, my lord. Should be was fixed, my lord.
My lord, interim, my lord, he appeared, statement recorded, but my lord, in this matter, there are other sufficient materials against the accused persons. And my lord, in this matter, I will point out to your lordship here, further custodial interrogation will be required, my lord.
Why?
Because my lord, here, my lord, at the time of my lord filing this petition, it was stated that he was a laborer, my lord, working in that construction company.
Committee.
But here, my lord, huge bridge over, my lord, your lordship may kindly over River Krishna, my lord. Was
No, you want to interrogate him
yes,
again.
my lord, because some other persons were yet to be arrested.
I'll direct him to appear before you.
Yes.
He will appear.
He
When?
appeared, statement recorded.
Now again he will appear. You interrogate him as long as possible.
Yes,
Weekly he will appear before him.
yes.
Heard Mr. H. Das, learned counsel for the petitioner. Also heard Mr. P. Borthakur, learned additional public prosecutor, who has produced the case diary of Krishna PS case number 38/2024. And stop. Learned additional public prosecutor has submitted that though the petitioner has appeared before the investigating officer and his statement under section 180 of the BNSS has also been recorded, however, considering the nature of offense involved in this case, his further custodial interrogation would be necessary, and therefore learned additional public prosecutor has objected to making the interim bail as absolute. Stop. On the other hand, the Mr. H. Das, learned counsel for the petitioner, has submitted that in pursuant to the directions of this court by order dated 14/8/2024, the petitioner has cooperated in the investigation and is ready to further cooperate in investigation. Hence, praise for making the interim bail absolute. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the case diary of Krishna PS case number 38/2024. Stop. It appears from record that the petitioner has appeared before the investigating officer, and his statement under section 180 of BNSS has also been recorded. Stop. The concern shown by learned additional public prosecutor that the petitioner is further required for interrogation may be addressed by imposing additional conditions on the petitioner. However, this court is of considered opinion that as the petitioner is cooperating with the investigating officer his custodial detention may not be necessary. Stop. In view of above, the interim bail granted to the petitioner by order dated 14/8/2024 is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. Stop. The petitioner is further directed to appear before the investigating officer once in every week for next 4 weeks or till the investigation is completed, whichever is earlier. Stop. Any violation of any of the condition by the petitioner may be a good ground for rejection of cancellation of the bail granted to him. With above observation, this anticipatory bail application is hereby disposed of.
Maybe the lordship. Lordship, there is not some accommodation, lordship. My senior Mr. Z. Kamal will appear in this matter. What will be the accommodation, lordship?
There are many accommodated cases today.
Lordship, he is in the way, lordship.
Okay, okay.
Highly obliged.
28, 29. Same. No,
29 mata nahi.
29, no.
Well, at
No,
29,
marking
I
jo,
was here.
marking jo.
29.
28 and 29 are similar. Is it?
Well, case that is similar, but my involvement may not is totally different.
Case is not similar.
Case is similar, well, same affair.
The series of.
Case diary is similar, but your case is different.
Different.
Okay. We may take up 29. Mr. Parashar?
Yes, my lord.
Yes.
Well, I am on interim, my lord.
You are on interim.
Interim on the city was called for, my lord.
What is the offense?
My lord, actually, my lord, I am the contractual worker, and on the basis of the my contractual job agreement, that is when I exhibit 2 at annexer 2 at page 16, by which it is my lord in second page 17. My lord, these are the works from para. First, my lord, it is started A, B, C, D, and E, F, G. These are the works have to be done by me, my lord. And the allegation is in the affair is that the person who lost the affair, he was the, my lord, at that time the junior engineer of this project, where I was working as an accredited engineer under him. Actually, not under him, under the, my lord, the GP secretary and the, my lord, BDO. I was entrusted the job. But he said that as the some 6 numbers of bills have been, the amount has been withdrawn. He said that if signature of his has been, my lord.
No, after getting in interim bail, have you appeared before
Yes,
the?
I have appeared on 18.
Your statement has been recorded.
I have 18.
You need his detention.
My lord, that person is not there, my lord. There is a specific note from the IO, my lord. I have, in the case diary, I have not found nothing about the court's order and statement. There is a specific note of the IO on 9/9/24 that in spite of the interim order, both the petitioner in both the case, 28, 29, they have not appeared before the court, my lord.
Then I am giving on an affidavit. CC camera is there, my lord. I went on 8/12, specifically, my lord, 18/8, specifically given this statement. And more interestingly, my lord, I'm sorry to submit, the IO, my lord, he demanded money from me. He said that you give some person about the money you have been, my lord, misappropriated.
That
This
may
is
be
the statement, my lord. I'm on affidavit, I'm signed, my lord. Affidavit.
Even, my lord.
Okay,
This is the fact, my
and
lord.
whether you submit the bail bonds.
I have given everything. My lord, fiancé, my lord, went there. Not only 1 day, 2 days I went there.
No, you find out, you submit an affidavit.
Yes, I have done. They have
And
not taken any, my lord, my
bond.
lord, this phone was not taken.
So you were not arrested.
Well, I have not arrested.
You were not
In
arrested.
that event, my lord, if he comes with an affidavit, then a direction may be given to the SP to verify, my lord.
Yes, my lord.
CCTV from the CCTV and all this.
Oh, yes, my lord.
If that is actually happened, my lord. But
In 29 also.
29, my lord.
In 20.
I went there, my lord, 18/8, my lord.
Okay, you file an affidavit. When
Yes, sir.
will you file?
I'll file everything.
When?
My lord, day after tomorrow, my lord.
Will
Because the
extend
lady has
the
to come from Morigaon, my lord. And my lord,
file on
meteorology-
Friday?
No, my lord, Friday a little difficult, but I'll be out of station from 12:30, my lord, to 14 itself, my lord. That means Monday, my lord.
28.
Monday, my lord, that will take.
APR
Affidavit কাছে জমা লাগলে এগুলো
মানে
হয় কি?
APR
Respective
APR
is 15. Same with me also.
28 is also same.
Yes, my lord.
You have
that's why-
appeared.
Yes, my lord.
You were
Unfortunately,
also-
I could not be on time, my lord. Right now,
You were also on interim.
I mean also in.
same day interim given, interim
After me, he got it, my lord. Showing me.
interim on for.
And I have also done there. I don't know how the IO is saying, my lord.
So 29 is
that
filing an
also-
affidavit.
With all respect, my lord, with all legality, I am submitting, my lord. This is a new ploy now being deployed by the IOs that
So
we are not going in. And
What
we
is,
also don't have the proof.
what is the way out?
Yeah, the way out is that we'll go and file the Hazira. They will accept it.
Yes.
And or they will call for the CCTV, my lord.
Yes, I supported the, I supported.
You didn't say, I'm saying now.
Yes, sir, okay.
Just you added. So there are many ways, but that thing should be followed there because in one of my case, my
No,
lord,
but you first file an affidavit.
I've already filed it in one, my lord. I'll give the number.
If
Yes. In the same case, yes, my lord, in the same diary, the same ploy has been adopted. And we were told
Not
on
in
that
this-
day,
not in this
diary
case.
was not coming. So we thought that the
No, no,
people will take
no,
time.
Mr. Kamar,
Yes, lord.
we are not going into other cases now. Only item number 28 and 29.
Yeah, right, my lord. No, my lord, why I'm saying, my lord, in this
If
case.
you file an affidavit, if we find
I-
that
No, today I don't know what he will say for me, my lord.
No, both.
same,
Both, no, we
Same.
will find it.
let them file an
Because I have,
affidavit.
I have brought it the message, my lord. I'll show it, my lord, if your lordship permits me. At what time he has went there, I have brought it sensing that this IO will say all these wrong things.
Okay, we'll,
And then
if
they-
we
then the-
find
And
in the
we should be
affidavit, we
taking
will,
action also, my lord,
Yes, yes, yes.
if we can prove it. He
then
has
we will
said,
take.
sir, I attended IO on 28 at Lavender in front of IO Mr. Raju
File an
Khetri.
affidavit.
His mobile number is this.
Heard Mr. Beleg, লিখিব। 28, 29, বেলেগ order হবো। Heard Mr. Z. Kamar Lanik, Senior Counsel, assisted by so and 29th heard Mr. P. Mahanta, Lanik Counsel, appearing for petitioner. Also heard Mr. K. Parashar, Lanik Additional Public Prosecutor. Lanik Counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by this court by order dated 14/8/2024. This is in 2029. 28 একে order. And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer.
Shall I give the date? On
Investigating officer on?
On
No,
28,
in 29.
24 at 11
Mr.
AM.
Mahanta. On which date?
On 28th, my lord.
No, no.
Both cases.
In my case.
In that case, Mount have to go.
In my case, my lord, 18, my lord. I went there on 18.
18,
8.
18/8, on
In my case,
18/8,
28.
20. Stop. However, learned additional public prosecutor, Mr. K. Parashar, has produced the case diary of Morigaon PS case number 190/2024 and has submitted that
As per the report of the IO dated 9/9.
as per the report, as per the endorsement given by the investigating officer in the case diary on 9/9/2024, the petitioner has not appeared before the investigating officer. Stop. On this, learned counsel for the petitioner submits that the petitioner may be allowed to file an additional affidavit to bring on record the fact that he had appeared before the investigating officer. The prayer is allowed. Let this case be listed again on Tuesday.
September last.
17, my lord, on 17.
On 17,
My lord, 17, I will be out of station, my lord, only on 18, my lord.
on 18,
Yes,
9, 2024. The interim order shall continue till next date. The case diary may be retained till that day.
Another case will of the
Similarly, from the same
affair,
diary,
it will be better.
2034 may kindly be tagged in, madam.
Not listed today.
Not listed today.
Oh, then.
It may be tagged in, madam, so that altogether.
No,
arising out
no.
of the same
For
diary.
that, a separate mentioning
Yes.
would be required.
I'll give it, madam, but if your lordship already it's filed, my lord, diary, sorry, affidavit. In that case, already affidavit has been filed. Madam. That's why I'm saying, madam.
There are three accused persons.
3 accused person.
Okay. In item number 28, learned counsel for the petitioner, learned senior counsel for the petitioner has also submitted that in another case arising out of the same FIR
Yes, madam.
in respect of 3 other co-accused, the petitioner had petitioners there in that case have appeared before the investigating officer, and in that case also the prosecution took the plea that they have not appeared, and hence an affidavit was filed.
Fine.
In
I can give that
that
date
case.
also.
The learned senior counsel prays for listing this
Yes.
anticipatory bail application along
Number
with the said case, namely AB
2034
2034 slash 2020.
Krishna Mohanta versus State of Assam.
2020, AB 2034 slash 2024. Let the said case be tagged with the instant bail application,
Right.
and let it be listed on
Then
17.
One go, we can take up the matter. Once a minute. Much of it.
Your lordship, my lord. FIR lordship may kindly see at page 8. Here is a case, my lord, where the husband and wife has disputes.
The petitioner also.
He has assaulted
Yes.
by
By
what
intent to,
weapon?
intent to kill them person.
What is the injury suffered?
That is that
No,
report is not
what is
available.
the statement? In the statement of the victim,
Statement of
where the injury has,
that's the diet also. কাঠৰ বাটা মাৰি ৰতেনালী মূৰত মাৰি গুৰুতৰভাৱে জখম কৰে. That's the statement of the other injured person.
let
My-
us call
let
for
the
the injury report.
Injury report
My
required.
lord, I have not yet interim, my lord. I may be allowed, my lord, interim. I will fully cooperate, my lord.
Okay, let him go to the. No, what is the statement of the victim? Let. Wait to me. Putul sound. Mr. What is your name?
GK Medi, my lord.
Heard Mr. G.K. Medhi, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. This application under section 482 of, what is your name? The,
GK Medi, my
no,
lord.
name of the
My lord, Moni Madhav Das, my lord.
Moni Madhav Das.
Alias Moni Madhav Das.
Okay. Though who assaulted, that is not there.
3 persons are there.
3 person assaulted, but 1 wooden log.
One more thing is, my lord, actually, what happened, my lord,
I have written in page number 4, pair number 4, my lord. Actually, 3 persons came on a same bike after having alcohol, after appearing in a funeral. And actually, this person, to whom actually so-called injured person, he fell down. He got injury only because of that, my lord. But when we rushed to them and tried to help them, then they quarrel among themselves and with us also, my lord. It was actually actual fact, my lord. Like one incident happened in the actually
It is your story,
Kalagunda, my
your
lord.
story.
My lord.
It is your story.
No, my lord. Actually, that is the actual fact so far information given by the person actually, my lord.
Okay, let us see the
My lord.
injury report. Till then,
Not shit, my
never
lord.
mind.
Interim.
This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Noni Madhav Das alias Moni Madhav Das, apprehending his arrest in connection with Jamaguri PS case number 109/2024 under section 126 within bracket 2/117 within bracket 2/109/3 within bracket 5 of BNS. The gist of accusation in this case is that on 11/8/2024, one Bishan Ale, ALE, had lodged an FIR before the officer in charge of Jamuguri police station, inter alia, alleging that on 10/8/2024 at around 9:30 p.m., his brother Ratan Ale, along with 2 other friends, were returning home from Gamiri Pal Gaon after attending funeral of one of his relatives. And when they reached Jamuguri Weekly Bazaar, near Jamuguri Weekly Bazaar, the 3 accused persons named in the FIR, including the present petitioner, tried to stop them and snatch the mobile phones and money. When the brother of the first informant resisted, he was hit by a wooden log, causing severe injury on his head. Stop. Learned counsel for the petitioner has submitted that the allegations leveled against the petitioner in the FIR are not true. He submits that, in fact, on the date of the incident, the brother of the first informant, along with 2 of his friends, were coming back after attending funeral in an inebriated condition. And thereafter, they met with an accident. And when the petitioner went there to help them, a quarrel started between them, and there was an infighting amongst the brother of the first informant and his 2 other friends. Learned counsel for the petitioner has also submitted that the brother of the first informant sustained injuries due to the accident, due to falling from the motorcycle in the accident. Stop. He also submits that he is ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Jamuguri PS case number 109/2024 and has submitted that there are sufficient materials against the petitioner of involving in assaulting the victim person. However, he submits that the nature of injury would not be ascertained at this stage as the injury report is not available in the case diary and seeks some time to produce the injury report. Stop. The prayer is allowed. Let the injury report be also called for. However, in the meanwhile, on perusal of the case diary, it appears that though a general statement has been given by the victim under section 180 of the BNSS 23 regarding involvement of the present petitioner, however, no specific details of as to how the petitioner assaulted the victim person is stated in his is mentioned in his statement. Stop. And as presently stop. Further, comma, as the nature of injury is also not known to this court, comma, till the arrival of the case diary, the petitioner, the custodial detention of the petitioner may not be necessary if he cooperates in the investigation. Stop. Hence, the petitioner is hereby directed to appear before the investigating officer of Jamuguri PS case number 109/2024 within a period of 7 days from the date of this order and to cooperate in the investigation. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with Jamuguri PS case number 109/2024, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority. Let the case diary be called for on 27/9/2024. Let the case, no, let the injury report be called for. Let the case diary be sent back and called again after
Along with the injury
updation. After updation.
Deeply obliged.
Said yes, injury should have said.
No, injury from the victim statement to injury.
For 326 earlier, and 307,
And 118.
118,
What is 118?
326.
324.
Okay.
324.
And 109?
109 might have,
Attempt to murder.
307.
307.
So
Case
in
diary
this
is
case,
there.
same prayer, Lordship, one injury report is not available, and also the statement of the injured victim, Lordship. This is not in the case diary, Lordship. Other eyewitnesses are there, they have implicated the petitioner. So injury
Statement of injured victim is also not there.
not available in the case diary.
That means victim is injured severely.
Not my lord.
Then why his
Even
statement?
first case, earlier we find my father was killed, my lord, in this case. The petition, your lordship, 1 and 3. Then 302 is pending, they are charge sheeted, they were arrested, they came out. After coming back, they were threatening them, my lord. As a result, both the party entered into altercation. And some altercation took place, injury may be there, but.
Nazrul Haq is minor.
Yeah, all the three are minor.
All are minor.
All are minor. It was maintainable last time, madam. One copy was, we have given in this.
No, this is
Yes,
now held by our division
yes,
bench.
madam. It is maintainable now. Madam. All are minor, 15 years, 17 years.
What is
17.
your submission?
Lordship,
Before whom they will surrender if
Lordship,
Section 12.
and on the place of organ also police recovered some one scabbard made up wood, one scabbard made up wood of touch things. Have to go through the judgment, Lordship. And division of government.
I have to properly go through that judgment, my lord. Any direction is there in the judgment, my lord.
no judgment says that anticipatory bail is
Maintainable.
maintainable.
It is clear cut.
So that is enough.
Yes.
Now, if it is maintainable, my query is, suppose I direct them to surrender. Then in case of juvenile, special police officers are,
Probation officers are
Probation
appointed, probation
no,
officers.
who,
They appointment probation officers normally they are. They, section 12 of juvenile at your loss will find.
no, my query is different. My query is, before whom they will appear? Will they appear before regular police officer who are, the IO is a regular police officer.
No, not probation officer, my lord, normally they are appointed. It is, their normal,
No, probation officer may not have any
yes,
connection with this case.
that's so.
IO is only handling this case.
My question was,
What?
maybe given my registry, let this thing sounds my.
No, what is your prayer now?
My prayer just have, I want my interim, maybe given if the injury report is not there.
Statement of the victim of injured
It
victim
is
is also.
not there, my lord.
During interims,
Yes, our statement may be recorded, man. All question of section 12, if you see, my lord, section 12.
juvenile justice. Heard Mr. H.R.A. Chaudhary, learned
Probation officer means an officer appointed by the state government.
senior
Head of-
counsel, assisted by Miss H. Ahmed, learned counsel for the petitioner.
Official probation officer means an officer appointed by the state government.
That's a probation
So,
officer.
on the Act of the section 12 to say, the arrest for it. They will be placed before them.
Bail to who person is pending.
They will run on the 300 or detained. They will circumstantial about to come to CRPC. Be released on bail with or without surety or placed under the probation of conditions.
Provision of probation officer.
Probation is.
Probation officer.
No, my query is before whom you will appear.
Why not here actually your kind say 12. 12 have been released on bail with or without surety or placed under the supervision of a probation officer or under the care of any fit person. Section 12 say. And probation officer meaning my your laws will find 40 section 2, so 48. Meaning of probation officer. Whether he is appointed or not, that we don't know. But section 2, surplus 48 one. That's section 12 emotions.
Appoint কৰিব লাগিব।
No, placing under supervision of a probation officer is an option. Option.
Yes.
They may be either granted bail or may be placed under supervision of
Care of a
probation officer.
Yes.
So
place
if you are placed under supervision of a probationary officer, it will not be bail for you.
supervision, my lord. In that case, I also maybe my lord that here. Normal course, once it is maintainable, my lord, in that case. So it may also the IO also. If you, I think, my lord, finally, if your lordship finds that, my lord, it is not a fit case for bail, then in that case, I think maybe under supervision.
Okay.
Section 107 of the Lordship JJ Act. 1071 Lordship, in every police station, at least one officer, not below the rank of assistant sub-inspector, with aptitude, appropriate training, and orientation may be designated as the child welfare police officer to exclusively deal with children either as victim or perpetrators.
Section 107.
107.
Subsection 1 of JJ Act.
The child welfare officer.
Special juvenile police. Child welfare. Police
In every
officer.
station, at least one officer not below the rank of assistant
So-
sub-inspector. Designated as the child welfare police officer.
This application.
You have to deal with that.
This application under section 482 of the BNSS, 2023 has been filed by the petitioners Nazrul Haq, number 2, Ikramul Islam, alias Ikramul Hussain, number 3, Rafiqul Hussain, alias Rabiqul Islam. All the three petitioners are juvenile, below the age of 18 years. The gist of accusation in this case is that, where is the FIR?
Yes. FIR is paid by Lord 18. 1/8.
That on 16/8/2024, one Hekmat Ali had lodged an FIR against the present petitioners before the officer in charge of Jinja Police Station, inter alia,
Jinja.
stating that on 14/8/2024 at about 9:30 p.m. the petitioners assaulted the younger brother of the first informant on the back, on his head, by means of a kukri, causing grievous injuries on his person. Stop. Learned, what is your submission? Is it?
My submission is actually, in fact, that altercation took place because both the parties, these two minors, 1 and 3, their father was killed by the brother of the informant.
Okay.
Then a case is
On
there.
an earlier occasion.
Earlier occasion. So 302 cases pending, the arrested trials going on. And page 22 is there.
Then regarding this incident?
Page 22.
No, then that was an earlier occasion.
Earlier, because of the enmities they might have said, they wanted to assault us when we are traveling. Then might have this incident took place. Might. They assaulted, they injured us. Might. We also went to the police station before that they filed the case. So we could not go to the police station, my lord, so ultimately we are there.
Okay, then its senior counsel for the petitioners has submitted that in the instant case, the petitioners are innocent and the allegations leveled against them in the FIR are not true. He has submitted that before this case, the uncle of petitioner number 1 and petitioner number 3 had lodged an FIR before in the
Jinja.
Against
Hamida Begum.
against whom you have lodged it.
Huh? Yes. Mother of the informant.
Earlier offense, earlier FIR was against whom?
Against Hamida Begum, wife of Diabo. কোন হয়? One and his mother, my lord. Your lordship, what are the contents, my lord, my one, my elder brother Nuh is my father.
That FIR is at page number?
Page 22. On 10/6/21. My elder brother Nuh, that is father of number 1 and 2, left the house without telling anything to any member of the family.
Against one Hamida Begum.
Informal sister and
Of killing
the father
the
of petitioner 1 and 2.
father of present petitioner number 1 and 3. Learned senior counsel for the petitioners has also submitted that in that case, who was arrested?
Yes, plea for your lordship, the present informant, your lordship will find uncle of the 1 and 3, prisoner did not claim any violence.
Anybody related to Hekmat Ali was arrested?
Yes.
Or
The prisoner came to learn the informant party killed their father and police in Hamida Begum, who is the sister-in-law of the present informant. Present informant sister-in-law. After completing the investigation, police submitted charge sheet against the informant party being charged number so and so.
who is Hamida is the sister-in-law?
Sister-in-law of the present informant.
Okay. What was the last time?
He's a Mahapi, this one.
In that case, the sister-in-law of the present informant was arrested. Was arrested and due to the grudge of that case, on 14/8/2024, when in the evening petitioners were returning back to their house from market, the informant restrained the petitioner and there was an altercation where both the parties sustained certain injuries, some injuries. It is also submitted by Lanet's senior counsel for the petitioner that the informant also sustained some minor injuries. Stop. Learned senior counsel for the petitioner has submitted that the petitioners are ready to cooperate in the investigation. And as they are, all the 3 petitioners are juvenile, their custodial interrogation may not be necessary if they cooperate in the investigation. Stop. On the other hand, Mr. D.P. Goswami, learned additional public, city is there?
City is here.
Learned-
Without the statement of the injured victim and a medical report.
Learned additional public prosecutor has submitted that though the case diary of Jinjia PS case number 64/2024 is available, however, the statement of the injured victim as well as his his injury report is not there, and therefore the nature of injury cannot be ascertained at this stage. He prays for some time for producing the injury report of the victim along with his statement. The prayer is allowed. Let the case diary be returned back and to be called again and to be produced again along with the statement of the injured victim as well as the injury report. On which date?
39 lots, 309.
On 39/2024. In the meanwhile, the petitioners shall cooperate in the investigation. Cooperate in the investigation. If they do so, stop. It is obvious that as the petitioners, you have given your birth certificates.
Yes, sir.
On what basis?
Birth certificate, given the school certificate, birth certificate of that. All the birth
It
certificates.
appears that the copies of birth certificates submitted by the petitioners shows that all the petitioners are juvenile and therefore their case shall have to be handled by special child protection and child welfare police officer attached to the
Their police station.
Jinja police station. Stop. The petitioners are directed to cooperate in the investigation. However, in the meanwhile, if they are apprehended in connection with the Jinja PS case number 64/2024, they shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the apprehending police subject to the satisfaction of the special police officer who apprehends them who detain them, who apprehend them in connection with the aforesaid case. Let this case be listed again on 39.
Otherwise, it will be better if you also specify before whom, otherwise again this problem will come.
No, I have not directed your appearance. Or it would be good to.
It is to appear, my lord, before whom he is to appear. In every police station, there is a special officer. Suppose he is not appointed, then who is the person before whom?
I have not directed your appearance. I have only directed that you will cooperate. And during cooperation, they will come to you.
Always.
May it please your lordship, my lord, the FIR is at page 19. It's a 3-page FIR. The gist of the FIR is in regard to a plot of land. Taking advantage of the situation at that time, the informant lost this FIR, saying that the FIR has been wrongly transferred. They have a will in their name. But if your lordship goes through the FIR, your lordship will find that he has not disclosed before the police officer that there was a civil suit pending in respect of the same plot of land. And there is also a complaint petition with same allegation pending before the concerned court. And in regard to the other issues, these are all being examined by the civil court.
You are on interim.
I am on interim. I have cooperated with the investigation. All the officials who have been arrested in connection with this case, they have all been allowed to go on bail. The person who sold the land, he was arrested, he was also allowed to go on bail. The buyer, they are all on bail, madam. Some is sit for 0 days, some for 2 days, 3 days.
Has he appeared?
appeared, my lord, statement record. Otherwise, my lord, very serious offense, my lord. Here not only, my lord, grabbing of land, but manipulation of government record. Here various, my lord, government employees were
What
also.
he has done, the present petitioner.
The present petitioner is a land grabber, my lord. He along with one other persons, my lord. He, my lord, initially, my lord, prepared a forced sale deed, my lord, in the name of one Pradeep Kumar Das. And thereafter, on the basis of that forced sale deed, land was mutated in favor of one Pradeep Kumar Das. The present petitioner is also along with other persons, my lord. One Tapas Chaudhary, his statement is also available.
How many accused persons are there?
My lord, I have given a list of the
Many
persons
accused
who have
persons
been
are-
arrested and allowed to go on bail and also who have been
Page?
page 97, madam. And this previous bill, initially interim was granted and they were made absolute. So far, madam, the FIR, if your lordship looks, the custodial interrogation may not be necessary.
Do you, what is your submission?
Yes, he now appeared statement recorded, my lord. Otherwise, my lord, considering the seriousness of the nature, my lord, I will leave it to your lordship, but otherwise, my lord, investigation substantially
You
progressed.
are not opposing.
My lord,
Submit fairly. If you don't want his custodial detention,
my lord, yes, my lord.
we will impose condition, he will continue to
Yes.
cooperate. Third, Mr. B.D. Moore, learned senior counsel assisted by Miss N. Zoma Pui, learned
And my lord, considering the ground that all other persons are on. bail,
learned counsel
and
for
he
the
appeared.
petitioner. Also heard Mr. P. Borthakur, learned additional public prosecutor. Learned senior counsel for the petitioner has submitted that the petitioner was granted interim bail by this court, subject to certain conditions on 3/5/2024. Stop. It is submitted by learned senior counsel for the petitioner that in pursuant to the said order, the petitioner has appeared before the investigating officer of Bhorlumukh PS case number 357/2023 and has cooperated in the investigation. Learned senior counsel for the petitioner has also submitted that in the instant case, there are other co-accused persons. Wait, page number?
97.
Co-accused. There are other,
I have given the name of 9 person, madam.
9 other co-accused persons are there in this case, out of which 7 are already granted regular bail and 2 are on pre-arrest bail. It is submitted by learned senior counsel that the petitioner shall continue to cooperate in the investigation. On the other hand, learned Mr. P. Borthakur, learned additional public prosecutor, has produced the case diary of Bhorlumukh PS case number 357/2023 and has submitted that the petitioner has appeared before the investigating officer and his statement has also been recorded by the investigating officer. Stop. In view of these submissions made by learned counsel for the parties, as well as the fact that the petitioner appears to be cooperating in the investigation with the investigating officer. Hence, the interim bail granted to the petitioner, namely Niranjan Rekha, by order dated 3/5/2024 is hereby made absolute with condition number 2 and 3 attached to the said order remaining intact. This anticipatory bail application is accordingly disposed of.
You are blessed.
Yeah, in this type of case, I always object, my lord. But my lord, here in this case, because he appeared and my lord, one except the
I have not mentioned that you are not objecting.
Yes.
Vehemently objected.
Yes, my lord.
Yes.
Made-
Wha-
made-
What is this?
Hold on.
The corpus.
Well,
Yes,
Pursuant to the affair that 18/7/13, the police has submitted the search sheet. Thereafter, the matter has been committed. And presently, the said case has been pending before the learned.
since when you are behind the bars?
My lord, till my lord, 1/9/2022, while the trial was my lord, going on before the learned session case, my lord, I was appearing. During the COVID period, I was filing financially crunched. So that my lord, I went to my lord Arunachal Pradesh for my.
You were appearing before the trial court.
Yes, my lord.
Then you defaulted.
I was on bail. I
Oh.
was appearing before the learned trial court below.
Okay.
Only for some months, my lord, I was defaulted. First, NBW was issued on 1/10/2022, my lord. Prior to that, my lord, I was all along present.
So when were you arrested again?
My lord, then my lord, I was arrested on my lord 4/4/2024, my lord.
4/4/2012. How many days you are in?
Since my lord, 4/4/2024, my lord.
At what stage the case?
More than people.
At what stage the case is pending?
PWs are going on, evidence is going.
How many PWs?
3 witnesses have been examined, cross-examined. I have annexed the copies thereof, my lord. From their statement, nothing has been disclosed. Any offense has been committed by us, my lord. I have enclosed as PW1 statement at page 32, my lord.
Then have you again prayed for bail before the sessions court?
Because my lord, I have been put behind the bar till my lord conclusion of the trial, my lord.
No, have you prayed for bail before
Yes, yes,
this?
sir, that was rejected.
Where is the rejection
My lord,
order?
that is, my lord,
Page
page my lord 24, my lord.
20?
24, my lord. Page 24.
What was the ground for rejection?
Ground was that paragraph number 8, my lord.
You can change,
Page 25.
then 10 also.
Then my lord. Paragraph 10, my lord.
Page 26, para 10 is in detail.
Yes, Mr. Parashar.
Yes, the trial going on next date is fixed on 20/11/24 for evidence. The order dated 5/9/24.
And how many total listed witnesses are there?
6.
Out of 6, 3 have been examined.
So, my lord, I am myself is
One, otherwise the trial has to go there, and they are NBW issued on 1/10/22, executed on 4/4/24, around 1.5 year. They are absconding in that period. Now, fact is that there will be a strict condition in each and every date without any fail. He has to appear. Otherwise,
who will appear, my lord? We
Heard Mr. M.K. Sharma, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS, 2023 has been filed by the petitioners, namely Umar Ali, alias Omar Ali, and Jalal Ali, who are detained behind the bars since 4/4/2024 in connection with the sessions case number 104 within bracket NL/2019, which is pending before the Court of Learned Additional Session Judge within bracket FTC Lakhimpur, North Lakhimpur. Stop. Learned counsel for the petitioner has petitioners has submitted that the petitioners are facing a trial. Charges are under what provision?
My lord, 395.
Are
395
are facing a trial for charges under section 395 of the Indian Penal Code. It is submitted by learned counsel for the petitioners that the petitioners were earlier on bail and were regularly appearing before the trial court. However, during COVID-19 period, they defaulted and the trial court issued non-bailable warrant against them on 1/10/2022. And ultimately they were arrested on 4/4/2024. Stop. Learned counsel for the petitioner has also submitted that there are total 6 numbers of prosecution witnesses listed in the charge sheet, and out of which only 3 have been examined. And none of the witnesses who have been examined have implicated the present petitioners. Stop. Learned counsel for the petitioner has also submitted that the petitioners are the permanent resident of where?
My lord. Kakoi Rajgor.
Of
And
Lakhimpur,
around
Lakhimpur
Kochi.
district, and they shall regularly appear before the trial court as and when required, and shall abide by any condition imposed by this court. Stop. Learned. On the other hand, learned additional public prosecutor has fairly submitted that as the trial is pending and 3 more witnesses have to be examined, the custodial detention of the petitioners may not be necessary if they cooperate in the investigation. And he prays for imposing strict conditions if they are allowed to go on bail. Stop. Considering the submissions made by learned counsel for the parties, as well as considering the facts and circumstances of this case, this court is of considered opinion that if the petitioner cooperate in the trial, their custodial detention may not be necessary for fair completion of the trial in sessions case number 104 within bracket NL/2019. Stop. In view of above, both the above named petitioners are hereby allowed to go on bail of rupees 30,000 each, with 1 surety of like amount, to the satisfaction of the learned additional session judge within bracket FTC Lakhimpur, North Lakhimpur, subject to following conditions. The petitioner shall appear before each and every date fixed by the trial court in sessions case number 104 LL/2019, and shall cooperate in the trial. Stop. Next para. Next condition. The petitioners shall not directly or indirectly make any inducement, threat, or promise to any of the listed witnesses or any other persons who may be acquainted with the facts of the case, so as to dissuade such person from disclosing such facts before the trial court. With above observation, this bail application is hereby disposed of.
One thing, total 5 witness, not 6. I'm sorry, out of 5, 3 examined. In
6 only, not
6,
5.
it should be 5.
5.
Total 5.
All right.
Well, in this case, my lord, I have taken instruction, my lord, petitioner appeared before the IO, my lord, on 22/1, my lord. Bail was granted on 19/1/24. Thereafter 22/1/24 appeared and took bail, my lord, along with his wife.
But the case diary does not.
My lord, yes, fact is that, my lord, I have obtained a report from the IO, my lord. Telephonically, I have talked with him, my lord. Subsequently, the IO has changed, my lord. Now, there is nothing in the case diary. The present IO, OC and come IO, my lord, of the case, my lord, he wrote a letter to the earlier IO that as part of the statement of the petitioner, they have appeared, but there is nothing, no bail bond copy and all this in the. So if it is in the hand of the earlier IO, that may be handed over. That is a letter to the, so SP letter has been given to the, my lord, this earlier IO, but that is informed. Now it is not sure that he has appeared. He
Statement is
stated as
also.
nothing. He on telephonic instruction by the present IO.
Let them again appear.
Yes.
You
that
appear
can be.
again.
Yes, yes, no problem.
You appear
Other-
again. We are disposing it off. You appear again. If you don't appear, the bail, it will be
Yes,
cancelled.
I'll appear.
Regarding appearance, but fact is that there are materials against him also, my lord.
No, but
Yes.
earlier interim
Yes, yes, interim granted,
was
my lord.
granted. Heard Mr. H. Das, learned counsel for, his statement is not there.
Statement, bail bond, nothing, my lord.
Okay, heard Mr. H. Das, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by
19/1.
this court on 19/1/2024. And thereafter, in
Appeared.
pursuant to directions of this court, he appeared before the
22/1.
investigating officer on 22/1/2024. Stop. And has cooperated in the investigation. Stop. However, Mr. K. Parashar, learned additional public prosecutor, has produced the case diary of Mornoy PS case number 21/2023 and has submitted that there is no endorsement in the case diary regarding appearance of the petitioner before the investigating officer. Learned additional public prosecutor has also submitted that he has telephonically contacted the investigating officer, present investigating officer, who is also the officer in charge of Mornoy Police Station. Stop. It is submitted that the present investigating officer has informed that the earlier investigating officer has been changed and the present investigating officer has written a letter to him through the concerned superintendent of police to hand over the bail bond,
If
if
available.
any, as well as statement of the petitioner, if recorded, to him. Stop. Under the above circumstances, this court is of considered opinion that the petitioner, the interim bail granted to the petitioner on 19/1/2024 may be made absolute with following conditions. Stop. The following condition dash. The petitioner shall appear before the investigating officer of Mornoy PS case number 21/2023 within a period of 15 days from the date of this order and shall cooperate in the investigation. If he does so within the said period, he shall be, no, within a period of 15 days from the date of investigation. Stop. Number 2, he shall not directly or indirectly make any inducement, threat or promise that condition. One, okay. Stop. With above observation, this bail application is hereby disposed of.
Item 61.
May I please your lordship, my lord? Here, my lord, petitioner was convicted under section 4 of the POSCO Act, my lord. And my lord.
Section 4.
Yes, my lord. Section 4, no? Section 4 of the POSCO Act, my lord. Here, my lord, as per ossification test. Yes, lord.
When were you arrested?
Lordship, this petitioner arrested on Lordship 29/6, Lordship. Already 74 days in jail custody, Lordship. We lost the FIR first. Our case was registered first. Subsequently, they have lost the FIR, Lordship. Their case was registered subsequently, Lordship. Now, Lordship, as per our FIR, Lordship, may I take our FIR first, Lordship? Because our FIR said, Lordship, that land belongs to our mother-in-law, Lordship. And they are entered into that land to Lordship, planting betel nuts, Lordship. And they said, Lordship, when we raised, Lordship, they entered and they assaulted us, Lordship. Subsequently, we lost the FIR, Lordship. Subsequently, they have registered their case against us, Lordship. There they said it is the land of their fathers-in-law, Lordship. That land dispute is, Lordship.
Now, assuming that there is a land dispute.
Yes, Lordship. Status quo is their, Lordship. Status quo is their, Lordship.
We are not for land dispute. What injury you have caused to the other?
Injury, Lordship. We have sustained injury, Lordship. Our case is 326 and 307,
But
Lordship.
that case is a different case.
Yes,
Assuming that you also sustained an injury.
Yes, Lordship.
But the allegation against
They
you.
have the encroachment, Lordship. They entered our land, Lordship. We raised them,
No,
Lordship.
assuming they encroach your land.
Yes, Lordship.
But here in FIR certain allegations are made against you
Yes, Lordship.
of grievously injuring the victim.
Yes, Lordship.
On that, what is your submission?
Lordship, that is, they have asserted, Lordship. We have not, Lordship, it's a Lordship just to defend ourselves, Lordship. We raised them, Lordship. They entered with a Lordship, Dow and all Lordship served instrument, Lordship. That is the land, they know, Lordship, their status quo is there, Lordship. Even knowing that, Lordship, they have entered that land, Lordship.
No, whether the other side suffered injury.
That, Lordship, will find in case there is, Lordship.
What is your submission?
My mission is, Lordship, mutual fighting is there, Lordship. Both sides, Lordship, injuries and Lordship.
Fighting can also be mutual.
My lord, some people know very well, my lord, after getting my lord, this couple, then first go to police station and raise the, my lord, lodging the FIR.
No,
My lord,
what is the
their
injury?
Their FIR is 40/24.
40.
And now they are seeking bail in 41.
41.
They went first to lodge the FIR.
Who? The other side?
Petitioner.
Petitioner.
They went first to lodge the FIR, but actual fact is that they, injury from the informant side is very much injury. One.
But the GD Lordship, can you see? Which GD
one cut injury in hand, one is a scalp, two is a scalp, total 4 person injured. All are first went to Bikali Model Hospital, then all were shifted to GMCH. Now from the final report from the GMCH is not received. But 3% cut injury in scalp, 4 inch, 1 inch, half inch, and other injury are there. Other I am not saying. Another person 4 inch into 3 inch into 1 cm in scalp. Another person 3 inch into 2 inch into 1 inch in scalp. 1 inch cut injury in hand. 4 person got cut injury in scalp. 1 is in hand. Case is under 326. So specific report from the GMCH is required. That is not even before us, but the eyewitness. Their statement of the injury are not available. They are under treatment.
Now,
by the eyewitness, they all implicated in the AB.
Monjil Haq.
Yes, he is very much and In the other case, Ilyas.
No, we'll go to other case later.
Yes,
on.
yes, this, yes.
Manjil Haq has
Manjil,
been
implicated.
implicated. Any incriminating material. Now Manjil Haq is behind the bars for
74 days.
74 days. Now whether you need his
Manjil, matlab 1, 2, 3, 4, 4 witness of the villagers. They are not the any from the family members. All implicated. All took the name of Manjil. There are several persons in the FIR, but
Altogether 21%.
but I am saying, my lord, all the persons are taking the name Manjil, all and other Ilyas. Only the complainant took the name of Akram Hussain. That is in petition number 2 in the AB. Others, my lord, in both the case, there are total 8 persons, except Akram Hussain. Akram Hussain's name takes only by the complainant, not by others. Though there are other people, in the several person in the FIR, but this 8%, 4 villagers, independent person.
whose name? Manjil.
Manjil's name took by everyone, my lord.
Then next.
Next, Ilyas is the
Ilyas for anticipated.
Ilyas and
Imran Hussain,
Imran.
Mohibul Haq, Khurshid Alam, Sainur Al Islam, Monwar Hussain, and only took complainant took the name of Akram Hussain.
Now what is the nature of injury caused to them?
Nature of injury, 3% injury in scalp, there in GM sheets, 62 GM sheets, and 1% hand cut. But nature of injury has to obtain from GHCH, it is not even. First, they have Bikali Model Hospital referred
74 days in jail.
referred to.
Now why do you need Manjil's detention?
Manjul, yes, on the length of detention, it can be, but materials are there, and others, anticipatory bill may be rejected.
Anticipatory, there are lordship 7% lordship, whether all are
But,
implicated or
Akram
not.
Hussain,
lordship. Because
I
cross case is there, lordship. Before rejecting that anticipatory bill, lordship, let the cross FIR kindly be called for lordship.
Akram Hussain, I am not, because only by the complainant only, but all the villagers, 4 persons, witness, independent witness, they took the name of the.
Heard Mr. B.
other person.
Chaudhary, learned counsel for the petitioner. Also heard Mr. A.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS, 2023 has been filed by the petitioner Manjil Haq, who has been detained behind the bars since 29/6/2024 within bracket for last 74 days, bracket close, in connection with Dhupdhara PS case number 41/2024 under section 148/447/325/326/506 of the Indian Penal Code. The gist of accusation in this case is that on 28/6/2024, one Muhammad Jonali Begum had lodged an FIR against 21 numbers of accused persons, including the present petitioner, inter alia alleging that the accused persons named in the FIR had illegally entered into the land of the informants brother's father-in-law, Shahinur Islam, and assaulted the husband of the informant along with 4 other persons, causing grievous injuries on their person. Stop. learned counsel for the petitioner has submitted that the dispute between the parties are mainly relating to possession of a plot of land and is of civil nature. He further submits that the due to the land dispute between the parties, there was an altercation between them, as a result of which the family members of informant also assaulted the family members of the petitioner side, and an FIR to that effect was also lodged
By the wife of the present petitioner.
by the wife of the present petitioner, which was registered as Dhubdhara PS case number 40/2024, corresponding to GR case number 626. No, GR case to continue. Is it 40?
Yes, Lordship, that is on page 20, Lordship,
yes,
GR case
40,
number is
40.
there.
40/2024. Stop. Learned counsel for the petitioner has also submitted that. Next paragraph. Learned counsel for the petitioner has also submitted that the petitioner has been detained behind the bars since last 74 days, and considering the period of detention, he may be allowed to go on bail. It is also submitted by learned counsel for the petitioner that the petitioner shall cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor, Mr. K. Parashar, has produced the case diary of Dhubdhara PS case number 41/2024 and has submitted that there are incriminating materials against the petitioner in the case diary, and 4 of the independent witnesses not connected with the dispute between the parties have also implicated him in the offense.
Active part, my lord.
In the offense alleged. It is also submitted by learned counsel for the learned additional public prosecutor that the 4 victims,
Injured, my lord.
4 victims sustained injuries in the incident. However, as the injury report from Guwahati Medical College Hospital and hospital could not be collected, hence the nature of injury cannot be ascertained at this stage. He vehemently opposed the grant of bail to the present petitioner. Stop. I have considered the submissions made by learned counsel for both the parties and have gone through the materials in the case record, including materials available before the court, including the case diary of Dhubdhara PS case number 41/2024. Stop. Though there are incriminating materials against the present petitioner in the case diary, however, it appears that the petitioner has been detained behind the bar since last 74 days, and his statement has been recorded.
My lord.
And his statement has also been recorded under section 180 of the BNSS. Comma 2023. Stop. Hence, considering the period of detention already undergone by the petitioner, this court is of considered opinion that if the petitioner cooperates with the investigating officer, his further custodial detention may not be necessary for fair completion of the Dugdara PS case number 41/2024. Stop. In view of above, the petitioner Mohammad Manjil Haq is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned
CGM Gwalpara.
Chief Judicial Magistrate Golpara with following conditions. Condition number 1 and condition number 3. With above observation, this bail application is hereby disposed of.
Highly obliged.
In anticipatory bail application, there are 7 out of 7.
Out of 7, my lord, against my lord, application number 2, Akram Hussain, my lord, only by the complainant, not by the my lord, co-villagers.
What complainant has said?
Complainant said that he also came along with this, my lord, specifically not
No.
against Akram
So
Hussain.
we allow Akram Hussain to go on.
Yes, yes, my lord.
Others we are rejecting.
Lordship, others are lordship, they are those who say lordship sustained injury, they are the accused of my case, lordship.
My lord, maybe, my lord.
They are the accused, they entered into our land, lordship. Let our case record can be called for lordship, that is the Golpara PS case 40, that can be called for. In the meantime, lordship, I may be, this petitioner may be protected. Until unless the entire picture has to be placed before the court, lordship.
Then we wait for that case diary, but no interim protection.
Now, lordship, at this stage, lordship, Akram is getting lordship, Akram, there is no material against Akram, lordship.
Akram will give interim
Yes,
protection.
other will be considered lordship after receiving of the cross case diary, lordship.
Third, Mr. B. Chaudhary, learned counsel for the petitioners, also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS, 2023 has been filed by the petitioners number 1, 2, 3, 4, 5, and 6 and 7, who are apprehending their arrest in connection with Dugdara PS case number 41/2024 under same section as in the previous case. Stop. Learned counsel for the petitioner has submitted that the petitioners sustained injuries. Petitioners themselves sustained injuries in the assault which occurred on the date of incident, for which an FIR was also lodged against the informant of this case, and which was registered as Dugdara PS case number 40/2024. And therefore he submits that case diary of Dugdara PS case number 40/2024 may also be called for before considering the anticipatory bail before considering the instant anticipatory bail application. On the other hand, learned additional public prosecutor has produced the case diary of Dugdara PS case number 41/2024 and has submitted that apart from the petitioner number 2, namely Muhammad Akram Hussain, against all other petitioners, there are incriminating materials in the case diary. Stop. After considering the submissions made by learned counsel for both the sides, this court is of considered opinion that perusal of the case diary of Dugdara PS case number 40/2024 would also be necessary for considering the instant anticipatory bail application, hence call for the same. Fixing when
25.
Fixing 25/9 for the case diary. In the meanwhile, considering the fact that against Mohammed Akram Hussain. Considering the nature of evidence against Mohammed Akram Hussain in the case diary, he is directed to appear before the investigating officer of Dhupdara PS case number 41/2024 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Dhupdara PS case number 41/2024, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 implement. Let this case be listed. No, what will happen to this? You will send it back or retain it? CD.
This CD maybe send back again.
Let this all also be required, Lordship, to cross, to
No,
verify both.
let the case diary of Dhupdara PS case number 41/2024 be sent back to be called back again on the
21st.
next date fixed, that is 25/9/2024. List accordingly.
Highly obliged.
Time over.
Item 10 may be taken day after tomorrow.
No, remaining item, it may be difficult to give date in each of the case.
Item 38, it's a delay condemnation petition filed in December last, but it has never reached. Item number 38, the delay of 183 days. It was filed on 15/12/2023.
Who is opposing?
Opposing says a POXO matter. He is appearing for as per number 2.
Okay, there is a opposition.
Amicus. The POXO matter.
So we'll take it up day after tomorrow.
My lord.
Item number
38.
38 day after tomorrow.
Obliged.
On 12/9.
10 may also be
Yes,
taken.
item
10,
number
10 my lord.
10 when?
Day after tomorrow.
What is the matter?
But custody of mobile, my lord. It has been seized, my lord, long back. Search sheet has been submitted. Case is listed several times, my lord.
No, mobile can wait. Let it be listed.
Item number 51.
No fixed date. It will remain. It will be listed in the next week by the registry.
May I present, Lordship, item number 43, Lordship. Lordship, today is 4th time Lordship left over, Lordship. Lordship, there is no entry order, Lordship. 43. Lordship, diary is available, Lordship.
43 service not completed. It's a POXO matter service as per office note, my lord, 7/8/24. Service is still awaited.
What is 43? 43 registry to fix a date in the next week.
My lord, item number 9, my lord. This matter relates to an interim relief, my lord, of 4 lakhs, my lord. So, and actually today was the date fixed in the lower court. And my lord, if we'll have to pay this amount, then this petition will become infructuous. So, can it be taken up day after tomorrow?
You,
And for the petition.
what is the matter?
Matter, my lord, this petitioner, he was directed to.
NI Act.
Yes,
NI.
20% of the check amount, my lord.
Okay, day after tomorrow.
Item number
9.
51. Item number 50 and 51. I am mapping of 51 and he said item 50. This matter can be taken up on the 19th. Here we have filed for IA, but IA never came up. The person was convicted for 10 years. They have been inside the jail for the last 4 years.
No, 50 and 51 on
19th.
19. 50 and 51 on 19. Yes, it is part. It has to be after 20.
No,
After-
36.
I remember it.
Date may be fixed.
After 20 at a date,
26.
26.
Um,
You are also there.
Yes,
You are also there, 26.
May I please, my lord? I beg to mention item number 12. In this case, my lord, the trial court had issued a non-bailable warrant against the petitioner. Item number 12. So we have challenged the order of taking cognizance. My lord, may kindly fix a date in this matter.
Total at a date. You suggested it.
My lord, is it possible to take up on 12? Item number 12.
13.
On 13. my lord.
13.
On 13. my lord.
Well, Article 36,
Deeply
can we, it will have file a bail in pending case, he is in custody for only 8 months.
Item
Item 36.
389.
Yes.
But it is in orders column. Why?
Yeah. This order will have bail with the order. Appeal is admitted, LCR has come, my lord.
Next week on a date to be fixed by registry.
May I lordship? Item number 48 lordship for hearing. Lordship, the imprisonment term is 7 years. He has already completed 6 years and 5 months lordship. It has come up many times, but didn't reach because of paucity of time, lordship.
Okay, otherwise it will become infructuous. When should we fix it? After 20.
Lordship. Lordship, can a date be given?
24.
24.
24.
Deeply obliged, lordship.
Item number 8, my lord. That has been LCR, my lord. Call for, my lord, a part heard has been there. That matter relates with that injunction matter, condonation petition. Your lordship has already heard it, my lord. So it was been fixed today.
Part heard.
Yes, my lord.
I remember, but
Yes, my
now I'll forget.
Yes.
When to fix it?
Well, day after tomorrow, my lord. So that it stays there.
Not day after tomorrow.
Then, my lord. On
In the
17,
no, not 17. You take a date after 23rd. Choose a date.
24, my lord.
24.
24.
Fixed.
24. Fixed, my lord. With all hello, obliged, my lord. Deeply.